the amounts of satisfaction.
The documents
It
need to
should
be
be the
produced.
reasonable
The
satisfaction.
documents need to be produced. Affidavit needs to be there.
They are saying that document has already been produced. They
Lordship,
have placed the document.
this is
They are before this court that they are saying that all the documents are placed, no objection has submitted. What satisfaction the authority wants? The satisfaction include the reasonable satisfaction according to the law, not beyond that.
They are coming before this court saying that we don't have any objection. I don't think what more remains. And the Guru Pada is very clear, if there is any defect, that should be intimated.
that's what I'm saying. No objection certificate from the legal heirs. That I fully appreciate that you are the only legal heir. I take it on the face value that you are the legal heir, but Lordship, let the matter be relegated to the authority.
Okay.
My humble submission is this, with the observation that if everything is found appropriate, they be granted the license. I will not stand in their way.
Very well. Please take down. Challenging a region order dated 6th of December 2024, passed by Subdivisional Controller Food and Supply Jhalda Purulia, in pursuant to
May I just come back?
yes, pursuant to the direction of this court in WPA number 25766 of 2024, within bracket Dilip Kumar versus State of West Bengal. Bracket close. Petitioner approached this court. Next para. It appears that father of the petitioner, Srishtidhar Kumar, was an MR dealer who expired on 29th April 2022. There are 3 legal heirs of said MR dealer as appearing from the certificate of the Tatuada Gram Panchayat. Certificate of the Prodhan Tatuada Gram Panchayat, dated 4th of December 2024. Petitioner is one of the son, and other 2 legal heirs are that is the one daughter and one son of deceased MR dealer. Are the respondent number? Who are you? The respondent number? Are the respondent number 6 and 7 before this court? Full stop. Are the one son are represented as respondent number 6 and 7 before this court. Full stop. Concerned subdivisional controller has turned down the prayer of the petitioner for appointment on compassionate ground with the observation as follows. As per statement 59. এই যে মার্ক করা আছে, মার্ক portion. It appears from the observation of the concerned subdivisional controller that he could not accepted the no objection certificate issued by the legal heirs, other 2 legal heirs of deceased MR dealer, within bracket respondent number 5 and 6. It is further observation of the subdivisional controller that documents were not placed within stipulated period. Full stop. Next para. Learned counsel appearing Nishing learned counsel appearing on behalf of the state submits that the authority were not satisfied about the documents as placed before him at the time of hearing. Having heard the learned counsels for the parties, also considering the matter, it appears to me that truly the application for truly the documents as required for consideration of an application for appointment on compassionate ground was not placed with the authority within stipulated period, but it with the authority within a stipulated period. But it appears from the order of this court dated 18th of November 2024 in WPA 25766 of 2024 that this court has accepted the plea of the petitioner and directed the concerned authority to consider the matter afresh. When a direction was passed by this court, the authority concerned had to accept the direction in its true letter and spirit. Full stop. Satisfaction, full stop দিয়ে করুন, satisfaction within inverted comma as termed, full stop করুন, satisfaction within inverted comma, quote unquote, satisfaction কথাটা quote unquote, satisfaction as termed in the statute is a reasonable satisfaction of the authority concerned in terms of the law laid down in the statute. The authority concerned must have acted to satisfy their satisfaction টা inverted comma মধ্যে রাখবেন, which would be in terms of direction of this court vis-a-vis the terms of the statute as well as the direction of this court passed in direction of a division bench of this court, direction of a division bench of this court passed in Gurupad Das versus State of West Bengal. Full stop. I make it clear that the concerned authority concerned must have aware about the fact of the law must have aware about the law laid down by the division bench of this court in Gurupad Das versus State of West Bengal in dealing with the applications for compassionate appointment. Full stop. The Honorable Division Bench in Gurupad Das has specifically directed the authority to consider the applications in terms of which was laid down in paragraph 14 to 18 of the said judgment. Full stop. I make it clear that next paragraph. The other legal heirs of the deceased MR dealer appeared before this court and submits that they have issued no objection certificate in favor of the present petitioner. I find there is no legal impediment for issuing dealership license in favor of the petitioner on compassionate ground. However, if any delay occurred in depositing the documents, that shall not be construed strictly in terms of the statute. Next para, the provision is benevolent in nature. The state authority must acted upon the premise that the application should be construed and decided according to the direction passed by this court as well as the direction of the division bench passed in Gurupad Das versus State of West Bengal. Under the above division, the impugn order passed by the impugn order dated 16th December 2024 passed by the concerned authority, concerned SCFS, is hereby set aside. Full stop. the matter be no, the matter thing. The petitioner is directed to approach the concerned SCFS matter be relegated back to the concerned authority for making a fresh decision in terms of the direction made in above. Full stop. If it appears to the authority that the petitioner is otherwise applicable according to law to get a license on compassionate ground, that shall be issued promptly. That shall be issued promptly. The concerned SCFS shall take the decision within 6 weeks from the date of communication of this order. The decision shall be intimated to the petition, to the parties, shall be intimated to the parties within 2 weeks thereafter. Under the above, the writ petition is disposed.
But in such times, vacancy notice shall not be possible.
Already order is there.
No, that order has been merged with the order passed by the subdivisional court.
In the previous, I have passed the order. Previous, this court has passed the order.
That is there, but that has been merged with the order passed by the subdivisional court.
Okay. Till next paragraph. Till the decision be intimated to the petitioner as mentioned in herein above. 62 page 62. The concerned authority shall not proceed to commission the license in favor of any person.
Grateful, your lordship. 22, no?
Or item 13 is the passed over matter. My lord, is a very important thing. Yesterday, your lordship heard this matter since some urgency is there. Item 13, passed over.
Oh,
Then I have to call up the all passover matters.
Your lordship may call up all the matters because all participants are waiting within 10:35. All matters have been called.
Let me conclude the list of the
Motion.
new motion matter.
Absolutely,
Thereafter, I will
absolutely,
again call.
absolutely.
Next matter.
My Lord, I beg to appear on behalf of the petitioners. My Lord, this is regarding, my Lord, curtailment of ration card from the MR shop belong to the petitioners. My Lord, vacancy notice, my Lord, at page, my Lord, 24.
25.
My Lord, Lordship, kindly consider page 25. My Lord, 8 line from the bottom. My Lord, subdivision, Uluberia, block, Udaynarayan,
2, serial 2.
serial number 2.
484.
Page 25, my Lord, kindly consider.
Subdivision Uluberia.
Yes.
My Lord.
Serial.
Subdivision Uluberia, serial number 2. My Lord, 484,
SCF.
oblique SCF, SCFF,
Subdivision
Uluberia.
Uluberia block 1 or 2.
block
Udaynarayan.
Udaynarayanpur. Lordship, kindly consider, my Lord, 8 line from the top, from the my Lord, bottom.
From the bottom.
My Lord.
No, no. Udaynarayan.
My Lord.
Subdivision Uluberia block Udaynarayan.
484.
484.
My Lord.
Serial number 2.
My Lord.
Urchi Sibpur.
Kurchi Binod Wati.
3000 किया है ना स्मूथ ऑपरेशन के लिए.
Mauja
Where
Kurchi
is your license?
Yes.
My Lord, page, my Lord, Lordship, kindly
20.
consider page 20.
Urchi.
My
Kurchi
Lord.
Binod.
License
Kurchi
is
Binod Wati.
Paragraph 6.
लाइसेंस तो
My Lord, paragraph 6, my Lord, I have stated
तो किचू हो गए ना.
Operation area of the
within the operation area of the
हाँ
petition.
ना.
okay.
तेरह
Division bench order is there. 1543.
Yes.
Madam.
Out of list होगा. Out of list.
Out of
Out of list.
ওই ডাইরেকশনটা আছে যেরকম করেছেন ডিস্ট্রিবিউশন কন্ট্রোল অর্ডার চ্যালেঞ্জিং 2000 না বলে দেবো চাট করে বলে ঠিক আছে
আজকে 21
ঠিক করা ওই দুটো আমি তো ডাইরেকশনটা এমনি বলে দিচ্ছি লিখে নেব Having heard the learned counsel for the parties, the state authority is directed to file the affidavit in opposition, file a report in the form of affidavit within 4 weeks from date, reply if any by the petitioner within 2 weeks thereafter. Full stop. Considering the facts and circumstances of this case and considering the matter that a batch of appeals being MAT 1543 of 2024 is pending for determination by the division bench in respect of the same issues. I think it necessary to observe that the present petitioner deserves the similar direction. Full stop. Accordingly, the state authority is directed to proceed with the selection process in terms of the impure notification, but so far as the commissioning of FPS license is concerned, that shall not be issued in favor of any person till the disposal of the batch of appeals pending before the Honorable Division Bench, being MAT 1543 of 2024. Full stop. Let the matter go out of the list. Parties are liberated.
Lordship
Affidavit
kindly,
service filed on behalf of the petitioner is taken on record.
Lordship kindly mention the impugned memo.
Yes, I shall
Impugned memo में kindly.
মেমোটা লিখে নেব। Impugn memo তো কোনো order এ করি-
484, Lordship.
Impugn memo, only I call the impugn memo, not nothing.
My dear.
Okay.
हाँ.
Next.
Correct. These are very carefully. Only the-
Number 23, I'm for the petitioner.
Milord, we are for the state respondents, Milord. Before my learned senior starts, Milord, I have a point of maintainability to take, Milord.
Okay.
Milord, in this case, Milord, there is an availability of alternative statutory remedy, Milord, which has not been exercised directly from the order of fine imposed by the subdivisional controller of food and supply, Milord, without preferring any appeal to the district controller of food and supply, while learned senior has preferred this appeal before your lordship. Milord,
Under Article 19 and Article 14, even if there is a provision of appeal, there are numerous writ applications before this honorable court wherein lordship has been entertaining, and
such exceptional
a number of
circumstances
honorable
has,
judges have been entertaining such applications.
such
So
exceptional
that is not,
circumstances,
that
Milord,
cannot
has
be an
not been
impediment
pleaded.
for coming up with an application under
I will-
226.
Milord, I will place, Milord, the decisions where 4 exceptions have been carved out. The 4 exceptions being violation of fundamental right, violation of principle of natural justice, order being passed without jurisdiction, and Milord, the challenging the virus of the statute.
Yes.
Milord,
Lordship can certainly
Whirlpool
keep the
Corporation.
point of maintainability
Whirlpool
open.
Corporation. Whirlpool.
Milord, Whirlpool Corporation is there, Milord. In 2021, Whirlpool has been considered, Milord, and the erstwhile Chief Justice of India, Milord, has passed a very recent judgment stating that where right is created by a statute which itself prescribes the remedy or procedure for enforcing the right or liability, resort must be to that particular statutory remedy before invoking the discretionary remedy under Article 226. So, Milord, that has not been exercised, Milord. Milord, that is my point of maintainability, which I am putting my learned friend that I'll take. I am putting him on notice, Milord. And if your lordship so pleases, Milord, he can place his case on merit, Milord.
Lordship can keep the point of maintainability open and hear the writ application and finally dispose of in the event.
No, issue is that in the Whirlpool and other orders and judgment and observation of the Honorable Supreme Court, in different forums is that whether the not point is that whether the petitioner was told to go to any other forum.
Whether
If
the
there
forum
is,
was
if
open
you
to it.
can demonstrate a case that the authority concerned has issued the order without jurisdiction,
My lord.
without any basis, and violating the fundamental right of yours to go
My
to
lord,
the
since my
other-
I appreciate what is falling from your
then you
lordship.
can come before this court on the first instance. Otherwise, if there is some remedy available, you can exhaust
I
the.
I am aware that the appellate forum is available. I am
Yes,
pretty much
now
aware.
the issue is that if there are some issues regarding calculations or otherwise, that is a factual matrix is there.
Hmm.
This court shall not enter into that.
My lord.
It will be forwarded to the appellate. This is the all along under the searchlight nowadays the law. Okay, so
My
you
lord-
have to demonstrate. You
My
have
lord,
to
my lord,
demonstrate
let
the
me
matter.
come back before your lordship. But in the event I find that the application that the petitioner should have approached the appellate authority, then I will beseech your lordship to send the application before the appropriate authority for consideration.
Yes, I can forward.
My lord, kindly gives me a week's time. Let me come back
For what?
for replying on the point of maintainability.
Okay.
I will not get into the merit of this application first of all, since my learned friend
Please
has
take
raised.
down. Learned counsel appearing. Your name.
My lord, Mr. Shisharno Bandyopadhyay and Mr. Ritesh Ganguly has been engaged, my lord. I am
Okay. A learned counsel appearing on behalf of the state authority, Mr. Ritesh Ganguly. Ritesh Ganguly, led by Mr. Shisharno Bandyopadhyay, raised the point of maintainability for entertaining the instant writ petition. Full stop. The learned counsel for the petitioner intends to file a reply, written reply, in terms of the objection raised by the state authority regarding maintainability of the writ petition. Let the reply be filed within
My
a
lord,
week,
my lord, 3 weeks.
within 3 weeks,
3 weeks.
within 3 weeks. Let the reply be filed within 3 weeks.
maybe take an exception to that reply.
You want to file exception? The state authority has liberty to file the exception within 2 weeks thereafter.
Yeah.
Let the matter appear in the daily list of March 2025. 25.
My lord, the affidavit of service may be kept with the record.
Daily list? Monthly list, daily list. Let the matter appear in the monthly list of March 2020. Monthly list.
My lord, the affidavit of service may be kept with the record.
Affidavit of service filed on behalf of the petitioner is taken on. Next.
I am for the petitioner. I am not placing this application. This is the written instruction.
Mala, in 24, Malad, I have made an application for addition of petty. Malad, this filing will serve his purpose. Malad, he is such a person against whom a prosecution should be initiated. Your lordship kindly sees how suppressing the entire material facts,
Not this.
confusing,
I will do this
misleading, Malad. He has filed.
No,
this-
you are.
I'm proposed added respondent. I have filed an application.
Have you
Malad,
filed
this
an application?
Yes, yes. This filing has impacted me. Malad, this filing of application has impacted me.
Very well. What is the application?
Malad, your lordship kindly sees that must be in the record, or it is still to come.
My instruction there were not placing this
Okay,
application.
not-
Withdrawing this application.
Malad, withdraw it, or he is trying to Malad escape. But how it has impacted me, and what sort of Malad,
Purpose would be served to hear-
this should be taken into account.
I
It
can
should be
take
taken
into
into
the
account.
your application in this matter.
Malad, application I have filed.
Give me the application.
Malad, he has made an application for for obtaining a license of MR dealer in the new vacancy. But what he has done, Malad, he is a member of the Gram Panchayat. That has been suppressed in the application. He has made an affidavit to that effect. Subsequently, he is making an affidavit.
And who are you?
Malad, I am one of the Malad intending
Applicant.
Yes, yes.
Very
Malad, there are every possibility for me to get the license in my favor.
You manage.
My lord,
Very
only for
But
the
you have
political,
managed-
my lord,
Okay, I understand. The issue is now not
Stop.
necessary to be enter into.
Mal.
Please take down.
Thank you.
Can 1 of 2025 is an application filed by one of the applicant in terms of vacancy ID number 202200230105 issued by Subdivisional Controller Food and Supply, concerned Subdivisional Controller Food and Supply. Full stop. The petitioner, no. The applicant of Can 1 of 2025 wanted to added as a party in the instant proceeding, in the instant writ petitions. Full stop. Next para. Learned counsel appearing on behalf of the petitioner submits that the petitioner is not want to proceed further with this matter. He hand over a written instruction. Let the written instruction of the petitioner be taken on record. Considering the written instruction of the petitioner, the instant writ petition is disposed of as not pressed. Full stop. Connected applications are also disposed of.
great.
My lord, I am for the petitioner, my lord. My lord, this is the service, my lord. My lord, the petitioner, my lord, one notification has been published on 2nd August 2023, my lord. Seven applicants applied for the notification, my lord. My lord, the petitioner application was rejected due to land dispute, my lord. The private respondent has been selected, suppressing the material facts that the land should be commercial, bastu or soft. My lord, she has submitted the land as danga. Danga means the heap land which is not be used as commercial, my lord. Now kindly see the notification once. Page 3, my lord.
Yes.
Page 3 of the notification, my lord. On the middle portion, clause 7, the documents regarding possessional right over the proposed place of business. In case of ownership or sharehold ownership, photocopy of the ROR, Porcha, registered deed of conveyance, purchase deed, gift deed, name and applicant, such and such. Documents showing character of land as Dokan commercial bastu. The private respondent submitted suppressing the material fact that the land belonging to Danga. Danga means the heap land. That cannot be used as commercial bastu or soft room, my lord. Not only that, there are another anomalies there, my lord. The circulation was published that the notification that the soft room was being allotted towards the cyclone center, my lord. The private respondent has been allowed, the soft room is situated near about 6 kilometers from the cyclone center, whereas the petitioner's soft room is situated only 2 meters
6 kilometers
from the cyclone center.
Location.
Central location, my lord. A petitioner's soft room is situated just 200 meters from the cyclone center.
You are saying that you are not eligible.
I am not eligible for due to land, my lord. But my humble prayer before your lordship, as they suppress the material facts that the Danga land has been submitted, but my prayer, humble prayer, my lord, kindly direct the authority to reissue the notification or another circular, my lord.
So a private respondent has been selected.
My lord, selected.
Okay. Yes.
I would like to hand over a set of instructions to your lordship because it's a bulky instruction. The relevant points are in this place before your lordship. Instructions আপনাকে কি করে দিব?
ঠিক আছে।
Yes.
Kindly seize R2, your lordship. R2 টা পেজটা বলে দাও।
Inquiry report. Page the one.
পেজ দেওয়া নেই না?
Inquiry report. Well, it doesn't inquiry report. Inquiry report not.
What is the name of the petitioner?
ওনারটা মামনি রাজ ঘটক,
Mamoni Raj Ghatak. And the private respondent?
Monica Das.
মনিকা দাস,
Monica Das.
Both reports are there.
Menoka Das.
हाँ,
Menoka Das.
both reports are there. Monica Das তো আছেই। Few pages, few paragraphs rather, or few clauses rather, more appropriate to say. 30. Page 15. The Kolkata Gazette Extraordinary, September 21, 2023. 15. 30. Comments if any. The applicant is financially solvent as per order number 3090 FS dated 18/11/2021 as amended order number 4063 FS SECTT Food 4P9/2021 Part 2 dated 24/11/2021. Then your lordship, the second page, 52. Go down with separate office space.
Yes.
Full address of the shop come go down with dar number, khatiyan number, Mauja, village, Gram Panchayat, block, police station and pin code in case of rural area, or holding number, street number, ward number, municipality, police station and pin code. Finding comments. Village plus PO Fatikpur, GP Buddha Khali, PS Kadwip, block Namkhana, district South 24 Parganas, pin 743347, Mauja Fatikpur, JL number 42, dark number 125, Khatiyan number 2563. Then whether go down and shop, that is D. हाँ, ठीक है। Whether go down and shop, counter, oblique office are adjoining connected. If not, then the distance. Yes. No has been struck off and yes. Now your lordship, 66. GPS location of of the proposed GPS location of A, the proposed shop come go down. If shop and go down are separate by more than 10 meters, mention location separately. Central point of the vacancy area. C, the previous FPS in case of resultant vacancy. Latitude 21, longitude given. Central point, Fatikpur cyclone shelter. Latitude 21, longitude this much. FPS of Bhagirath Bagh, latitude this much, longitude this much.
Distance is 1900 meter.
Yes.
my lord.
Yes. And findings and comments lastly.
Yes.
The godown situated 1900 meter from central point, but submission of all documents are okay and godown condition is hygienic. And its size has been covered by the GO 1465 FS dated 10/4/2023 and the applicant is financially solvent as per order number 4063 FS sector food FP this dated 21. So the applicant may reserve the FPS license and done the positive recommendation for the same. After this, lordship is fully aware that there is a committee. After that, inquiry officials of the Subdivisional Controller Food and Supplies Kwakdeep have duly inquired the application of Srimati 4. First page, I'm reading paragraph 4. Maneka Das for FPS dealership license 22/12/2023.
You are reading?
Page, first page, your lordship.
Okay.
First page. Now, after this inquiry, this
Okay.
has been referred. And that was forwarded to the District Controller, Food and Supplies, South 24 Parganas through vacancy module portal in online system for necessary approval from the competent authority. The file has been sent to the higher authority after incorporating necessary marks for the district level fair price shop selection committee of this district. After getting necessary approval from the Department of Food and Supplies, Subdivisional Controller Food and Supplies Kwabdik has issued offer letter dated this 11/12/2024 for FPS dealership license in favor of Srimati Menika Das, wife of Suvendu Das, on 11/12/2024 to deposit security money and license fees. R5. At present, issuance of FKS dealership license in favor of Srimanika Das is under process. Pertinent to say that Srimati Mamoni Raj Ghatak, wife of Animesh Ghatak Waddeep, was another applicant of the said vacancy. She has applied for the FKS dealer license and subsequently has submitted all relevant documents through vacancy module portal in online system of the Food and Supplies Department dated 17/9/24. After that, inquiry officials of the Subdivisional Controller Food and Supplies Kwaddeep have duly inquired the application of Srimati Mamoni Raj Ghatak, wife of Shri Animesh Ghatak, for FPS dealership on 22/12/2023, copy enclosed Annexure R4, and subsequently her application has been rejected by the competent authority on the ground that the ROR of the proposed land is recorded in the name of Hari Krishna Databhya Aushadhalaya Managing Committee as the Rayat and Ramhari Ghatak as the encroacher, but the gift deed has been carried out between the applicant and the claimed legal heirs of Ramhari Ghatak since deceased. Thereafter, Srimati Mamoni Raj Ghatak, wife of Sri Animesh Ghatak of Fatehpur District South 24 Parganas, has filed writ petition before the Honorable High Court, allegedly that godown location of Srimati Manika Das Suvendu is situated 6 km away from vacancy location, that is Fatehpur Cyclone Center, Kwaddeep South 24 Parganas. But it is only 1900 meters away from the central location. Inquiry report of the area is attached as Annexure R2 and it is situated within service area of the notified vacancy.
My lord, may I permit, my lord, then I must file the exception to the report, my lord. It is 6 km from the cyclone center, out of which 3 kilometers is Brickville Road, 6 meter wide Brickville Road, and thereafter 10 meters wide road, my lord. And it is 6 kilometers means, my lord, from High Court to Sialda station, railway station, about 6 kilometers. But the godown of the petitioner is near about 200 meters, my lord. But I have been rejected on the basis of, my lord, LOR record of rights, my lord. But the record which he has submitted before the authority, my lord, this is recorded as Danga. My lord, Danga, even, my lord, as per the conversion of LR Act, my lord, Danga cannot be converted, even Danga. My lord,
Danga can be converted, not the pond.
My lord?
Danga can be converted, not the pond.
My lord, maybe, my lord, but according to notification is very clear, Bastu, commercial or shop.
But sir, petitioner is not the eligible person.
My lord, petitioner not the eligible for due
You
to.
are saying so, how can you challenge
My lord,
a competent person?
my lord, I was one of the party on the application.
Maybe you were the party, but you are not eligible. You have no locus.
No, I was not eligible, my lord, but as I have locus as because, my lord, I was one of
You
the
have the
party.
locus.
My lord, in the matter
You
of
cannot challenge a successful candidate.
no, my lord, there is a locus standing. Supreme Court judgment is there, my lord. Locus standing. Even anybody can challenge. No,
Anybody
only.
cannot challenge. No, you are
Well,
not the aggrieved person.
Anybody
lord,
cannot challenge. I have objections.
My lord, in that regard, my lord, as per notification, it is not fulfilled, my lord. But I must file the exception to the report as because it is not 900 meters, my lord. It is about 6 kilometers from the cyclone center, and out of which 3 kilometers is 6 feet road, 6 feet road, my lord. And the location is totally people-less area. My lord, the godown is situated. My lord, that's why my application. My prayer is simple, my lord, kindly reissue the notification, my lord, then in accordance with law, my lord.
No, that cannot be considered at this stage.
Then kindly allow me to submit the exception, my lord. My lord, yes, I filed submit the exception, my lord.
Then in that case, your lordship, I have to hand over the bunch of instructions.
No.
That's because it is simple instructions. It is
Yes.
not affidavit also. It is
not
whatever
the
has
affidavit.
come to me instantly for my purpose of arguing before the honorable court. I am doing that.
My lord, until and unless, my lord, the affidavit has not been submitted, my lord, how I will prove that, my lord, the distance is 6 kilometers, my lord. It is 900. They have stated that it is 900 meters.
These are the statutory formulas.
And moreover,
How one person should be appointed as a FPS dealer.
and moreover,
There are some guidelines.
Guidelines.
My lord, but it is not.
According to the guideline, they have gone to your locality, they have verified the
আমরা তো inquiry করে
distance.
এটা বলেছি।
Well, but LOR ROR record is not showing that, my lord.
What are what?
Well, kindly see the notification.
They have visited the spot
That's
and there is a longitude, latitude, distance.
that
My
is
lord,
what I'm
maybe my notification is very clear. The ROR should be shop, commercial or dokan. My lord, it is Danga land. Danga, no, my lord, kindly see the notification, my lord. Kindly see one
I
second.
know the notification. Dokan commercial Vastu. This
My
is the
lord,
notification.
my lord.
During inquiry, they have noted that the
with reason.
Inquiry, my lord, your lordship is very well about the inquiry, my lord.
Sir,
if you
anybody.
are a competent person,
My lord,
I can allow.
my lord,
Allow you to file affidavit.
Anybody, lordship, any person who does not get the grapes are sour.
Yes,
no,
yes.
Yes.
nothing that.
Yes, very much
Nothing
like
that.
that.
He did not file the complication. As per notification, Vastu, commercial and shop.
Dokan commercial Vastu.
Dokan
This is
commercial Vastu, my
the-
lord.
This is the notification.
My lord.
Then
And thereafter, my lord, longitude, latitude, my lord, that is also under question.
why?
My lord, it is
How
not
can you
within,
question?
within 900 meters, my lord, my lord. It is 6 kilometers from the cyclone center. My lord, the candidate has been stated it by affidavit. He swear affidavit by stating this. That's why, my lord, I am challenging.
Okay, you file affidavit. You
My
file
lord. Grateful lordship.
affidavit. Affidavit of service filed on behalf of the petitioner is taken on record. Ms. Sonal Silan, learned counsel appearing on behalf of the state authority, has placed the brief history of the matter as forwarded by the concerned subdivisional controller. Having perused the report of the state authority, it appears to me that the report should be filed along with the affidavit. Accordingly, the state authority is directed to file a report in form of affidavit within 4 weeks.
Within
Well,
4 weeks from that, exception if any, by the petitioner within 2 weeks thereafter. Full stop. Let the matter go out of the list. Parties are liberty to mention.
That is true.
4 weeks party তুমি মেনশন করবে আমি দিয়ে দেব
ঠিক
ওর
আছে,
পরে তুমি
ঠিক
তোমার
আছে। Thank you, madam. Grateful lordship. Yes.
আমরা পয়েন্ট আউট করব 26
My lord, accommodation.
accommodation
My lord, Mr. Boral, Oin Kumar Boral is in this matter advocate on record. His mother's got a fracture today. That is why he is in hospital. So one day accommodation, maybe on Friday, fix on Friday.
Not Friday, not this week.
not
কোনো নাম
27 Lordship, I am for the petitioner. On the last occasion, one more petition was filed which I had withdrawn for the reasons that there were some errors in the petition. Unfortunately, Your Lordship, in this petition also there are some typographical errors. To that effect, I am filing one affidavit, Your Lordship, supplementary affidavit. Just that Control Order 2013 has been written as Control Order 2010. No such order exists, Your Lordship. So 13 is the order.
Okay, file is supplemented.
And another is, Your Lordship, Annexure P1. We have challenged the order of 2023 But over here, by mistake, the order of 2022 has been annexed, your lordship. So
Then you have
both
to
we are-
file a press.
we are filing a supplementary affidavit to that effect, your lordship. Both the corrections have been made over there, your lordship.
In the prayer,
Not in the prayer, your lordship. I'm pointing it out, your lordship.
what you challenge?
I have challenged, your lordship, the notification of 2023, the vacancy notification of 2023. But unfortunately, P1 has been annexed as vacancy notification of 2022. The same is written in the petition as 2023, but over here in the annexure,
No, you have challenged an order of rejection.
order of rejection has been challenged, your lordship, and it arises out of the notification of 18th. I'm sorry. Out of the notification dated 29th August 2023.
And you have annexed on another
I have annexed the notification of
18 July 2022.
2022, your lordship. To that effect, I am filing a supplementary affidavit, your lordship.
And you have challenged an order 14th of June 2024.
20.
Where is the order? No order is there.
Your lordship, after my interview was conducted, your lordship, after that, no steps were taken by the department. So we preferred an RTI application. Over there, we got to know that my application has been rejected on the ground that one of my distant relative is already in the FPS this field, your lordship. She's having an ownership of that FPS license.
So why you come to this writ court?
We have come to
You
this
made
because,
a representation. Whether you have made a representation?
your lordship, I don't know the exact merits of the case, your lordship, but
No, you file a press.
Is this
the second time file of this?
so the maintainability are
It
concerned?
would better to file a press.
Oh, then
This is the third time.
third time.
so your lordship have made the necessary rectification just.
There are three writ petition as I've understood. Is one of the writ petition the liberty was given to file afresh.
Sir, এটা last একটা ছিল স্যার, এটা আমি
And
withdraw করছি
prior
না।
to that, the impugned order was not tagged with the order is under challenge was
Yes.
not.
I am wanting that order. That is not there.
Then how is the maintainability? এখন open করে দিন, please.
So what you want?
Your lordship, as per my instructions, I have made all the rectifications in the supplementary affidavit, your lordship.
Such type of rectification have you? You go to the authority concerned with a representation, thereafter you will come. I will allow to not press the matter. Okay.
Then your lordship, kindly, not today, then I'll ask my senior. I don't have instruction about that, your lordship.
কি হবে এগুলো করে?
Sorry. Come on next week. Next.
28 my application, my lord. Relating to my lord vacancy notification issued by this authority concerned, my lord, I am the notification which is typed copy, your lordship will find, and that notification is at page my lord 19
এটা কি কোনটা এসে?
content.
Block
My lord, block Ramnagar 2,
Ramnagar 2, serial number
my lord, serial number, my lord, 2,
2.
page 90.
Memo number 1538.
153. And the order which has been passed by your lordship,
Thank you.
Deepak.
my lord.
Where is your license?
My lord, license sheet has page, my lord, 14. And type copy, my lord, 14.
Village Kanpur,
My lord,
Balisar.
my lord. And the adjacent villages which are, my lord, included in the area of the petitioners. And that license has been given, the notification has been issued. And identical order has been passed by your lordship. My lord had been pleased, my lord, to accept the same. My lord, the leave was granted by your lordship to file afresh. That's why I have come before your lordship in this writ petition. I have stated in the paragraph. My lord, although the copy has not been added. Serious, my lord, memo.
May I request only one thing? Before passing of this order, Millard,
Yes.
kindly give me some time because I have to ascertain, Millard, two things: whether this particular notification is really affecting his right or not. If it is falling within the same moja, then definitely it is affecting his right. If it
Area
is-
of distribution is the same, then it is
then
affected.
I have, well, this particular information I have to Millard ascertain. Kindly give me 1 day time.
My lord,
Only 1 day.
Come on next week, Monday.
Yes, yes.
my lord, I will not be here, my lord, because I have lost my elder brother. I have to go to my native place at Minnapur, my lord. That's why I am not able to, my lord.
So when you are
Next week, my lord, next week, my lord, I will. The
next week, you will return.
my lord.
When you will return?
Friday.
Friday.
Then your
Next week,
lordship will.
Friday.
Next
Then
Friday.
come after thereafter. I'll keep it pending.
My lord.
Come on 5th of February.
Yes, lordship.
Come on 5th of February.
5th of February.
In the same area, my lord. Yesterday, your lordship has been.
Let him take instruction.
Yes, lordship.
Please take down. This matter be urgent today
Orderটা আছে তো?
due to the reason for specific instruction as required to be taken by learned counsel appearing on behalf of the state authority. Let the
হ্যাঁ
matter,
আমি সেম মৌজা কিনা দেখে নিচ্ছি আমি। অন্য
let the
কোনো
matter appear in the list on 5th of February under the same heading. 5th of February.
as well as সুমন সেনগুপ্তে is doctor. সুমন
Affidavit of service be kept on record, my lord.
My lord, may I file by affidavit of service, my lord? It's very.
Item number 29.
Yes, my lord.
My lord, I am appearing for the respondent number 2.
Ministry of Textile publishes, my lord, jute packaging mandatory orders whereby, my lord, the jute mills are to manufacture jute bags which are taken by the state procurement agencies for packaging of food grains. That is a mandatory jute packaging order, my lord. That is issued by the Ministry of Textiles. Now, my lord, what has happened in this case, my lord, the jute commissioner has issued production control supply orders, my lord, for the petitioner to manufacture for the jute bags. Respond number 2, my lord, is the Odisha State Supply Civil Corporation, which is a state procurement agency for the end consignee for whom the jute bags are manufactured. My lord, there were 3 PCSOs placed, production control supply order, in the month of February, March, and October 2024. Jute bags manufactured by the petitioner inspected everything in order, my lord. Only the dispatcher was awaited. My lord, the jute PCSOs specify that the jute bags are manufactured ex-factory. That means, my lord, the end consignee, in this case, respond number 2, are to lift the jute bags from the petitioner's factory. They failed to do so. My lord will kindly see from the movement order, the respond number 2 lifted from practically all the jute mills in the state of West Bengal, barring the petitioner number 1. Thereafter, my lord, the writ petition was filed, service was effected. Now, my lord, they have started lifting jute bales in deferred manner. The jute bales have started lifting. 980 jute bales are to be lifted, my lord, from the factory of petitioner number 1. 180 jute bales have been lifted, my lord. The rest, around 700, are left. I was humbly praying, subject to my lord, may it be adjourned for 3 weeks, and the respond number 2 may complete lifting of all the jute bales. The
My
balance.
lord, my instructions are that we have started lifting the
Yes, my lord, they have started.
bales.
That's what I submitted, my lord. They have started lifting only after service of the writ petition, my lord. But we, whatever it may be, my lord, it's in the interest of my client also that the jute bales are lifted, because, my lord, unless the jute bags are lifted, payment will not be received, my lord.
So you are now lifting the jute bags?
Yes, my lord, we are in the process. We will
They have started
complete
lifting,
it.
my lord, but in this matter, my lord, item number 29, it's 980 jute bales. So, my lord, they have only lifted 180 jute bales. What I was humbly submitting, subject to my lord, may it stand over for 3 weeks. And thereafter, my lord, we shall come and apprise, my lord, as to what is the status, my lord, whether they have lifted entirely or not. Again, otherwise, my lord, my clients will again have to come back with a fresh writ petition. My lord will kindly.
That will be better.
No, my lord will kindly adjourn it for 3 weeks, my lord.
My lord, we are giving assurance that we
almost
will
a
pick
year,
up
my
all.
lord,
There is
not
no
lifted.
requirement. My lord can dispose of the writ petition.
No, my lord will kindly not do that. The PCSOs are from February 24, March 24. It's almost a year, my lord.
So you are appearing on behalf of whom?
Respondent number 2, my lord.
My lord, they are
Odisha Civil Supplies.
They are the main, and my lord will kindly record my learned friend submission that his clients are lifting, and they will lift, my lord.
Please take down. Petitioner challenged the action of the respondent number 2 for not lifting the jute bags from the mills of the petitioner. It is the contention of the learned advocate appearing on behalf of the respondent number 2 that respondent number 2 has started lifting the jute bags. Considering the fact there are huge consignment and lifting may take necessary time. Accordingly, the instant matter be adjourned for 4 weeks. Full stop. Let the matter go out of the list. Parties are liberty to mention.
Grateful, my lord.
My lord, item number 30 also similar facts with the other concerning another jute.
Petitioner number 1 is only different, my lord. Same facts, similar facts.
Item number
30, my lord.
30, my lord.
My lord, in that the total quantity was 1100 jute bags, my lord, out of which only 3.
Item number 39.
30, my lord. 30.
Oh, 30. Same order.
Same order, my lord.
Item number 30, same order. Similar direction.
Okay.
Well, for the petitioner.
Yes.
This application seems almost a replica of a previous writ application in which interim order was passed by a coordinate bench and the final order allowing the application was passed by your lordship. Just for lordship's reference for once. An application for appointment of a MR dealership was made. The application was the application filed, online application, better to say, was turned down without citing any reason. The petitioner came up before this honorable court. Eventually, initially, even in that matter, there was a stay. Thereafter, lordship had passed the final order. Exactly, almost in this case.
Kindly seize page number 22, your lordship, annexure P5.
Lordship may kindly take up from page 11. This is the notification for FPS vacancy. Page 11.
Yes.
This is the vacancy notice, my lord. Page 14 is the application.
Yes.
Now lordship may skip over to page 18.
18.
This shows the receipt of the application by the concerned authority
on 27th of September
My lord, and
2022.
eventually the rejection which my client eventually found traced out in the end of 2024 before filing of this application, because there was no communication, written communication or oral communication to her. She
Rejected.
clicked rejected on, my lord, page 22, kindly sees on 27 September 22.
And you made a representation.
Representation made. After she came to know, because my lord, there was no oral communication, there was no written communication.
Communication we don't do.
That correct. My learned friend is correct that there is no communication. How am I supposed to know that my application has been
It's
turned?
online. Online you can see it.
Every litigant is not expected to be so tech savvy that she will regularly.
When you apply, when you can apply
actually,
online, you can see the rejection also.
Use the system of technology.
Yes.
You have to
that is the
provide
rule.
the technology.
That is the rule.
Yes.
Now, my lord, this just once,
No,
not even a sentence.
Okay, just wait. When you file the representation.
Well, the representation was filed on. This was on. What call it? Matter 5th December 24.
5th December 2024.
No reason, even a one line why my application has been turned down. Nothing.
There is no scope in the online portal to sign any reason.
How am
There is
I?
no scope.
Well, it is exactly like the previous application. Simply turned down, nothing. No justification, nothing. And I have invested quite a lot of money in making that big go down.
Or maybe you have
And even the
candidature has been rejected.
Here it
Because
is.
there may have some other person who is more eligible than you.
As far as my knowledge goes, as of now,
you go to the query with the concerned authority.
It is
I'm
still
disposing of the writ application, directing the authority to.
The representation I can see, your lordship, on P6. P6 he has made.
Yes.
Let it be considered.
Yes.
Let it be considered.
Definitely you must have stated all these
Everything
reasons.
has been stated there.
Okay. Please take down. The petitioner has applied for FPS license in terms of notification dated 8th of August 2022 issued by the concerned SCFS. Full stop. She applied for the vacancy on 27th of September 2022. Thereafter, one inspection was conducted at the proposed shop-cum godown of the petitioner. However, from online, she came to know that her candidature was rejected. Full stop. She made a representation with the authority within bracket P6 bracket close. The authority has not responded. Thus, she approached before this court. Ms. Sonal Sinha, learned counsel, appearing on behalf of the state authority. Submit that the authority may be directed to consider the representation. Having heard the learned counsels, the incident writ petition is disposed of, directing the concerned subdivisional controller food and supply to consider the representation of the petitioner within bracket P6 of the writ petition and dispose of the same by passing a region order within 6 weeks from the date of placing the instant order with the authority concerned. Full stop. I make it clear that the concerned authority shall give the appropriate opportunity of being heard to the petitioner.
My lord.
Full stop. The decision shall be intimated to the petitioner within 2 weeks thereafter. Full stop. I make it clear that this court has not entered into the merit of this matter. The concerned authority is at leave to dispose of the representation according to the law. Full stop. Next para. As the affidavits are not exchanged, the allegation made in the writ petition shall be deemed to have been not admitted.
My lord, one indulgence, my lord, till my representation is considered, let there not be any further
No,
fresh
no.
notification for this
No,
week.
Your Lordship.
Otherwise, it will be infructuous.
No, Your Lordship.
Well, the affidavit of service may be kept with it.
Next.
Too, I am for the petition.
I am appealing on that.
Here, my lord. License is a
Similar issue.
similar issue.
I
Page
have a
40.
little objection to that extent.
Come on that day,
Very well.
5th of February.
On the same day.
Same. What are the 5th.
33, my lord, same.
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 Why are you
Okay, give me the back.
nowadays?
The license already expired.
Here, my lord, license is at page 40.
Which is expired.
The notification date, my lord, at page 16. Annexure P3.
It's expired and yes, coming 2025.
Yes.
My lord, the notification is at page 20. Serial number.
Item number. Serial number.
Serial number 20.
Serial number 20.
20. 247 memo. Dated, my lord, left hand side. 29th May 2024. Subsequently, the license has been issued in favor of the son. After, my lord, the father's name was there, my lord, he was issued the license. Subsequently, he has been given the license.
I
Hello,
cannot understand what
Even I didn't understand.
My lord,
This is
my lord,
J. Ache Shubhubroto Banerjee.
his father was
father
MR
আছে।
dealer.
His father was Emma Taylor. He expired.
Subsequently, he has been
He
given
expired.
my
His
lord.
father was expired. He made an application and he got the
Got
license.
license.
So the Shubhobroto Banerjee is
Son.
running the license.
License. His last-
Expire has
And
it's valid till 31/12/2024.
Then it has been renewed subsequently.
Where I do not find it. Where it is.
Where is
Have
the
not, I
where is the
do not
document?
have, my lord. The alternative has
Where is the document?
There, my lord, your lordship.
This-
I
Come
make
on
an-
count 5th with the document. Come with the document. Next.
Jamming led by Mr. Huda, my lord. I'm the petitioner in this matter. আমাদের 34 মানে 34
Who is appearing for the petitioner? Item
Well,
number?
মানে I'm appearing for the petitioner, my lord.
You are appearing for the petitioner. Take the petition mic of the petitioner. Yes, what is the matter?
My lord, it is a notification matter, my lord. I've received a license. It is in annex number P1, page number 22, my lord. And there is a notification in page number 24, my lord. I'm being led by Mr. Huda, my lord.
You challenge the notification dated 21st of May 2024.
Yes, my lord. My lord, there's a order that I have challenged for issuance for the ration card dealer, my lord. I'm showing, my lord.
Yes. What do you want?
My lord, my license, what I was holding and running the business, is being challenged by tagging of another license of the dealer.
Whether license was issued, another license was issued or not?
Yes, my lord.
In favor of whom?
An order was passed by the department, my lord, and challenging that order.
Whether you challenging any order or any vacancy notification?
I'm challenging the order, my lord.
Order.
Yes, my lord.
Order dated? Are you not ready?
Well, yeah, I've just received the brief, my lord.
Then come on next week.
Well, Mr.
My friend has challenged page 24, that is the vacancy report, the order, and while 2 policy decisions of the state at
I understand. Come with ready. Get ready. Let the matter appear next week. Next week, not this week. Next.
That I appear on behalf of the petitioner, affidavit service to the.
For this statement, led by Mr. Bandhavada.
This is my affidavit service, Lord. The private respondent is also there, that I have served. This one taken out. Copy the document.
Yes, what is the matter?
That kindly come to page 21 first. The second round of litigation after your lordship passed an order. Kindly permit me to place page 21 first. I was granted the ration dealership. I have been running for decades. Suddenly, my dealership was suspended for the time being on the basis of some allegations which are found to be incorrect subsequently. Just allow me to place just two lines from that order. Page 21. The total, as a result, total population of suspended MR dealer of Sunil Kumar Haldar, petitioner before your lordship, under ward number 8, had been tagged with MR dealer Shanot Kumar Gain of Diamond Harbour Municipality, ward number 9, in the interest of PDS with immediate effect. So, after suspension, some of the all the ration card holders were detagged from my dealership and tagged with another person, the private respondent. Now, this order was cancelled. This order of suspension was revoked. Your lordship will find it at page 28.
28?
Yes, madam. Page 28.
Yes.
FAS Sunil Kumar Haldar, Dhanberi under Diamond Harbour Municipality was suspended under the aforesaid reference, and the said suspension is revoked with effect from first fortnight of October 2018, and the entire Panchayat area population except the population of Diamond Harbour Municipality of Sunil Kumar Haldar will be relinked from the tagged account. So direction was given that suspension order is revoked, but there is a rider except the population of Diamond Harbour Municipality, which we were those ration card holders under the Diamond Harbour Municipality were tagged earlier before the suspension. So my claim was that after the revocation of the suspension order, I am entitled to get all the ration card holders which were there before the suspension. Now that there's a government circular, kindly just place me, permit me to place one circular. That your lordship will find it at page 64. Type copy 65. Just I need not trouble your lordship. It prescribes that there should be at least 5,000 to 6,000 ration card holders for each dealership. That's the criteria. Now, Lord, I challenge this order of suspension, wrongly making the prayer. I have challenged the entire order. Entire order suspension, that is revocation of suspension, 9th of October 2018. The prayer should have been to the extent that Diamond Harbour Municipality area has been, instead of doing that, inadvertently my advocate record committed the mistake by challenging the entire order, and I was also challenged before the district controller this order. The prayer was defective. Then I came up with your lordship, and your lordship considered my prayer. At the outset, I made submissions that this is the wrong mistake I have committed. So your lordship considered this my application at page 92. Lordship passed an order that you directing the in the meantime they have issued a notification. Kindly permit me to place this order.
Yes.
From page 92, second paragraph. The brief fact of the case is that present petitioner was such as first paragraph also. Another advocate of the appearing of the petitioner submits that some wrong prayer has been incorporated in the writ petition. However, considering the factual aspect of the writ petition which provide for necessary relief according to the law. I did not trouble the lordship. What I did, I challenged the entire suspension order, which was in my favor, but except that part I should have challenged. That was vehemently opposed by the learned friend state that I have challenged that order. So the petition is not pending. The lordship heard the matter at length and passed this order. Brief fact of the case is that the present petitioner was a SCFC dealer. His license was suspended by order such and such by the concerned subdivision commissioner. At the time, population of the ration card holder dealer were delinked by the state order of suspension. The present petitioner approached the authority concerned subdivisional controller, Diamond Harbour, after hearing the petitioner had issued an order of revocation of suspension that I placed on 9th October 2018, and it has been specifically ordered that the entire Panchayat area of the petitioner population except the population of Diamond Harbour municipality of Sunil Kumar Haldar will be relinked from the tagged account of FPS dealer Sunil Kumar Gayan in the interest of PDS. Such order of relink was not complied with by its concerned authority. Accordingly, the petitioner has filed a statutory appeal before the district controller. During the argument, the learned counsel appearing on the petitioner submits that the appeal is infructuous due to wrong prayer, so he will not press the appeal before the authority concerned. By submission of CAN is the prayer that the petitioner that the subdivisional controller has issued a new vacancy on 21st May 2024 in Moja such and such, the same Moja. It is the case of the petitioner that such area was within the linked population area of the present petitioner, which was illegally delinked by the order of suspension. He further submits that though the order of relink was made by the authority concerned, but they did not comply the order. He submits that at this juncture, if the new vacancy notification was allowed to be continued, the present petitioner shall suffer immense. Mr. Such and such government advocate appearing for the state authority raised strong objection and specifically pointed out that the prayer in the writ petition, he also submits that till the statutory appeal is pending, the present petitioner cannot challenge the new vacancy notification. He further pointed out that at present, the present petitioner is not holding any license in respect to the vacancy of location of Dhanberi. It's not correct. It's there. So he has no cause of action and he tried to intrude a new cause of action. Having heard, now this is the observation of your lordship, Lord. Having heard the learned advocate of the parties, it appears to me that the prayer of the writ petition is very short and simple in the nature that the order of concerned authority on 9th of October 2018 be complied with in its true letter and spirit. The order of relink was not done. New vacancy notification in respect of the area Dhanberi is about the population which was earlier linked with the present petition. It is true that the concerned authority must follow their order, but in this case, the authority was not followed. The order dated such and such. Under the above aspect, I think it necessary to dispose of the matter by directing the concerned subdivision controller, respondent to comply the order dated such and such regarding relink of the ration card holders with the present petitioner. In respect of the prayer of the state, it appears to me that in respect of CAN, I think it is necessary that this prayer is out of the ambit of the state petition. If the authority concerned is decides the issue in respect of the order dated such and such, there may have no necessity for publication of new vacancy notification. Of the above observations, the writ petition is disposed of by directing the present petition to approach the concerned authority. Respondent number 3 of this petition after disposing of the statutory appeal through a specific representation. Concerned authority must dispose of the representative petitioner within a period of such and such after giving opportunity to the petitioner and to communicate the decision. Now, that was the decision. Then I moved the representation before the concerned authority pursuant to lordship's solemn order. That is at page 96, representation dated 23rd October 2024. Now, before just going to that representation, since there the statutory appeal was directed to be withdrawn, I also moved the district controller page 100. District controller received the copy of my petition for withdrawal. Prayer is at page 103. That withdraw the appeal. This is the district controller. Pursuant to lordship direction, I must withdraw the appeal. Page 100, the petition starts before the district controller and prayer is at 103 that withdraw the appeal. Now, the representation. Now, page 103, the prayer before the district controller that withdraw the appeal.
Page 103.
101, 100 starts The district controller receipt is just above 18th November 2024, 100. I'm just reading the prayer portion, 103 of the
You
writ petition.
annexed separate
That- No, another, has your lordship got 100, page 100?
page 100. You have also annexed the order of this court.
Oh, my lord, oh, this is wrongly, my lord.
So,
Now,
what is the where you
my lord,
are-
the order
order of the appellate authority?
No, order of the appellate authority is not
Dated?
there. My lord, I have filed the petition before the appellate authority on 18th of November 2024.
Very well. It is page 104.
Yes, my lord, I'm sorry. The prayer is there. Now, pursuant to lordship's direction. Now, the detailed representation which has to be considered by the subdivision controller, that is at page 96.
Okay.
Now, that in that petition, the same contention has been made that I am entitled to get the number of ration card holders before my suspension, before my revocation. Be that as it may, your lordship directed them to consider to comply the order. That order also contains the exception clause at that, but I am also agreed by that order. So I have also challenged that order before lordship here in this writ petition. But my entitlement is on the basis of their own circular, that I am entitled to get at least 6,000 and whatever the number of were there before the revocation. And that number
DRC is there now.
that I have stated at page 98 in the representation. At present, I have only 12150 at the representation, but they have not considered this aspect also. Page 98, my representation, second internal page, third internal page.
What order do you want now?
But I have challenged they have considered my representation. They have said, no, we have complied with the order of suspension, but they did not relink the number of populations which are that place. Yes. That is
The municipality.
yes. This is my only submission.
Let me take a report from the school.
Yes, my lord.
What is the number of DRC we are running with?
My lord.
My lord, kindly come to page 94. My lord's order, my lord. 94.
Yes.
My lord, the second last paragraph, my lord.
Yes.
May I read, my lord?
Yes.
Under the above aspect, I think it is necessary to dispose of the matter by directing the concerned subdivision and controller, the respondent number 3, to comply its order dated 9th October 2018, my lord. My lord, now kindly comes to the order 9th October.
I have placed.
Except the municipality.
Yes, my lord. It has been done, my lord. My lord has given direction to comply with that order. The same has been done, my lord.
Now he is before this court that the number of DRC is very poor.
My lord, he was suspended, my lord. Because of his suspension, my lord, this has been cut down to given to some other, my lord. And my lord has directed to consider this 9th October 2018 order, my lord. And the department has done this, my lord. And my lord kindly comes to
I have
prayer
that challenged that. Yes,
Prayer
I have
C, my lord.
challenged that part also before your
My lord,
lordship.
then my lord,
Prayer C.
prayer
Yes, see,
my lord,
page 16.
16.
That part, exception part, I have challenged also. That's why we not.
Except the population of
Yes,
environment.
yes.
This portion you challenge.
He is challenging your 9th and or to modify this order, my lord. My lord has given this order, my lord. We have complied with my lord. Again, he has come challenging this order, my lord. This comes under res judicata, my lord. He is challenging the same order, my lord.
No, that was the entire order, but it is the exception. But in any case, my case is based on
The order
circular.
has been
I'm
complied,
entitled to get after the
circular is
revocation
not-
of the suspension. I'm entitled to get. But it is my mistake in the earlier repetition that I have challenged the entire order. That's why I'm not.
The order has been complied.
That
my
should be
lord. Again,
considered. But it's my
it
right.
cannot be
legal right.
challenged, my lord.
It's legal right, except that part. According to the notification, they must comply the notification, their own notification, which I placed 6,000 at least.
It is for the new vacancy.
Page 28, their government own notification.
What order new new
But
order you want?
the number of ration card holders which are before suspension, that should be restored. Because
it is a penal measures.
it is revocation.
He was
No,
suspended.
unless
was
if
cut
the
off, my
no,
lord.
if the suspension order was not valid, they would not have revoked the they revoked on inquiry they found satisfactory. That's why. Otherwise,
Yes,
they
my
would not
lord.
have revoked the suspension order.
There
Once
was-
they revoke the suspension order, it goes. The penal
No,
action
no,
goes. On inquiry, it is suspended, it is revoked.
Very well.
My lord.
Please take down.
And it's a kind of
Having
punishment. my
heard
lord.
the having heard the learned counsels for the parties, it appears to me that the matter cannot be disposed of without giving, without exchange of affidavit between the parties. Accordingly, the state authority is directed to file a report on the form of affidavit in the form of within 3 weeks from date. Reply, if any, by the petitioner within 2 weeks thereafter. Point of maintainability as raised by the learned counsel for the state be kept open. Let the matter go out of this particular liberty mention.
Get liberty to mention, brother.
Liberty to mention.
Mother, oblige.
Lordship, I am appearing for the petitioner, Lordship. This is my affidavit of service.
And for the statement.
Lordship, I'm here. The petitioner is a fair price ration dealer, Lordship, and he is deprived with the notification, vacancy notification, which is annexed as a annexure P3, page 18, Lordship. The grievance of the petitioner is that, Lordship, that he is aggrieved by the vacancy notification in his area, Lordship, where he is having around 4,200 ration card holders, Lordship.
What is the ground for challenge?
Lordship, the ground for challenge is that if some new recruiter or any other dealers are tagged with this petitioner's dealership, Lordship, then petitioner will be deprived with his right that he is having very fewer ration card holders, and this is his only way to earn, Lordship, the bread and butter. He earned his bread and butter by this profession only, Lordship. If some other persons are going to be tagged with his dealership, then it will harm his business, Lordship.
How many DRCs are there?
Lordship?
How many DRCs are there with you?
Lordship, it's around 4,200, Lordship.
It's 8,200. Paragraph 4. Page 4.
Lordship, might be it's wrongly typed as 8,000.
Yes, 8,000.
Paragraph 4, page 8,200.
So much population.
Lordship, I have to take instruction on that, whether it is 8,000 or not, Lordship.
You have written in you'll read with affidavits.
Might be, it can be a technical error, Lordship. Lordship, let a report can be filed to the state so that it will be clear that whether they are holding this much population or not. Then Lordship may file an order, Lordship.
You have not drafted well. Yes.
Your Lordship will find at page 17 that is the policy of the government. On the basis of this order, my lord, issued by the Food and Supply Department, my lord, this notification at page 18 was issued. Now,
The
this
policy decision was not challenged in the writ petition.
not challenged. And from the pleading, my lord, your Lordship will find 8,200 cards, my lord. It's huge numbers. Not possible, my lord, to handle for one dealer. So, my lord, I do not think, my lord, there is any infirmity in issuing this 14th May 2024 vacancy, my lord.
Yes.
Lordship, let a report may be filed by the state
By
by which we will get to know whether actual ration card holders are that much or not, Lordship.
You are saying that 8,200 ration card you are dealing with.
Lordship, that can be more or less, Lordship. that
You
is
are
not
the affidavit before
appropriate.
this court, not like that. You have not challenged the
Policy
order of the
decisions.
concerned authority regarding the population in the writ petition also.
It's 17, my lord, is
How can you be entertained? I am giving liberty to you to file afresh. Having heard the learned counsel for the petitioner, the instant writ petition had the learned counsel for the parties, the instant for the having heard the learned counsel for the petitioner, the instant writ petition is disposed of as not pressed, with a liberty to sue afresh on the self-same cause of action.
great.
Oblige, Your Lordship.
38. For the petitioner. This is a case, my lord, where your lordship has already passed some orders. The new trend has been introduced by the subdivisional controllers of the respective subdivisions. All on a sudden, huge quantum of food grains are being displayed in the EPOS machine and also the official portal. The distributors never delivered the same. Then subsequently, lesser quantum of goods are being allotted. Now, if you kindly turn up what happened in this case. My license is at page 24. After death of my father, I got the license. Page 24 is my license.
Yes.
Then, my lord, kindly come series of letters. Kindly first, my lord, page 25.
Yes.
There is a mistake in the stock. Please rectify the same. This is dated, my lord, 2nd of February, 2023. 1 year back. Next page, kindly see every month, 17th March 2023. যাতে আমার ক্লোজিং ব্যালেন্স সংশোধন হয় সরকারি নিয়ম অনুযায়ী রেশন দ্রব্যাদি বন্টন করতে পারি because I am unable to deliver the goods to my consumers. Then page 27, kindly see 24. Every month I'm writing letters, each and every month. Then all on a sudden, page 30, your lordship, kindly turn up without giving reply, without intimating anything to my queries and my grievances. This has been addressed to the MR distributors. Kindly see, with reference to the above, this is to inform you that the Food and Supplies Department has approved the following quantities of food grains as allocation for the month of June and July 2023. In respect of the dealers, namely Raju Molla, Nirmal Molla is my client, Arjun Begum, Shamina Akhtar, so-and-so, Anjan Ghosh, so-and-so, and Sanju Ghosh. The details of allocation has been mentioned in the exit sheet of duly enclosed. As per the instruction of the department, the stock to be provided, well, I fail to understand who is the departmental authority. The stock to be provided to the fair price shop dealer from the balance stock of distributor, which will be replenished in the next month of allocation, August, so additional allocation for the fair price shop. Hence, you are requested to provide the food grains to the following dealers as mentioned in the Excel sheet and intimate the so-and-so. Then, Mala, next page is the Excel sheet. I fail to understand anything from this Excel sheet. It has never been given to me. It has only been issued to the respective MR distributors, which will appear from 1, 2, 3, 4 of page 30. But I continued my representation, page 32, 33, every month up to page, my lord, kindly come to page 40, every month. Now, your lordship, kindly take up paragraph 25, page 13 of my petition. Page 13, 25 and 26. At page 13. Your petitioner states that after several representations, when your petitioner was awaiting with an expectation that the respondent authorities would adjust the stocks of quantum of ration articles, all on a sudden in the allocation order of month of September 2024 for distribution month November 2024, in the allotment order of month November 2024 for the distribution month December 2024, and in the allotment order of month December 2024 for the distribution month January 2024, from such huge excess shown quantity of stocks of ration articles, a considerable portion of stocks of ration articles has wrongfully been adjusted by way of delivering lesser quantum of ration articles than the required quantum of monthly allocated quota ration articles. It is pertinent to mention here that more or less 20% quantum of ration articles have been deducted from the quantity of monthly allocation, so and so. Documents I have annexed. So today, my lord, before this court, I am only praying, let them file a report or affidavit showing that these quantum of articles have been delivered to me by the respective distributors, which is appearing in my post machine. Just the account balance, distributor got it, distributor delivered to it to me, which will be appear from the stock register of the distributors. And in the meantime, not to deduction. I am paying for pair A, my lord. Pair A, page 21. This is at least my lord, my 5 matter is appearing in the list. Pair A at page, my lord, 21. Let them file an affidavit dealing my all allegations and disclosing that the distributor got these articles and he has delivered the same to me. I'll be out of court, your lordship impose cost upon me. I cannot take leave or leave the goods from the godown. It is a 3-tier system, your lordship knows. Distributor get it from the government godowns, then they deliver to me, and then I distribute it to the consumers. So if the distributor can show that this quantum of articles which is appearing in the disclosing in the EPOS machine, the entire thing will be done. I have to accept the same.
Let them take the decision.
Well,
Calculate
decision, let them file an affidavit or report. That's the whole because otherwise, my lord, kindly consider these aspects of the matter.
Then this court has to calculate what amount is there like that. It will better to send them to calculate.
Well, only one paragraph that these are the account of the distributor. He has lifted it from the government godown and distributed to the dealer. This is the cash memos, this is the delivery orders. Let them say so. I'll be out of court. Huge quantum. All on a sudden in the 5 morning, it is displaying in the post machine. There are other matters also appearing in the list. Your lordship will your lordship possibly has considered some matters also.
May I be permitted?
Yes.
My learned friend, my learned senior friend is aggrieved by the order passed by the subdivision control. Now, what he is proposing today to come up before our lordship to give the details. I believe the writ court is not the fact-finding authority. This is a court. There is an appeal provision is there. Kindly have a look the appeal provision once again. Any distributor aggrieved by an order by the district controller food and supply denying the issue.
Why you pass the order?
That is the 20% reduction.
No, no.
He has intimated.
Hearing so many arguments for
Paragraph 25. He has said so.
No.
20% reduction.
Under which provision of law this order has been passed? I shall prefer an appeal.
No, it is page 30 is an order regarding direction upon the distributor.
Correct. Now kindly come to the page 13.
Page 13.
13.
Yes.
Now see, Millard. Paragraph 25. It is pertinent to mention that here in less, more or less 20% quantum of the ration article have been deducted.
Yes. How?
So this is the Millard the point of agreement.
There must have some order.
Yes, that has been given to him. He is not saying anything. I can show to your lordship whatever my
suppression of facts you are saying that I have not annexed this document.
Did I say anything? But Mr.
Just
Shara,
you told that
you
I have not annexed.
You exhaust your energy, then I have to say or allow me to say.
Okay. Mr. Senugupta, start. No, he has said that he is receiving more or less 20% quantum of ration article.
Correct.
It is
This
his
has
saying.
been deducted.
There
But
is no such
Millard,
order here.
I would not go into the merit of the case why this has been done, rightly or wrongly. If it has been,
You are saying that there must have an order.
Exactly so.
Then you place the order.
I will place the order.
Okay.
In the form of affidavit, my lord.
Yes.
No, Joseph, এটাই বলছি.
And if you lordship kindly
There must have an order, I think, in now.
order. Only the distributors have been directed not to give.
Yes, only distributors are there.
I have not been intimated, no opportunity happening, nothing.
Lordship wanted to dispose of this matter by Millard relegating the same to consider the representation.
Then it
I
will
will
consider.
not come up with the Millard. I can say I will not come up with the Millard the data for which Millard Mr. Shahara is putting me on the booby trap. I will not come up.
No. I want you to submit a report whether any order was passed on.
And what is the reason? What is the reason?
No, any
No, reason or otherwise.
he has not said anything about the order.
Correct. He has not said so. Just
He has
give
not
me a
said.
moment.
He is receiving 20% less.
Yes.
This
Correct.
is only his submission.
Yes.
Correct.
More or less 20% less. No
Correct.
such order is there. So you are saying there must have an order of the authority. Very well. Please take down.
Would your lordship have a look into my instruction once? Would you lordship have a look?
No, you just
Bring the order and other things. Very
please take down.
next turn.
My lord, page 40 is the exhaustive representation.
Okay, you made a representation.
Numbers, at least 10. It starts from, my lord, page 30 onwards.
These are the, I understand. These are the,
Page 30, kindly come.
yes.
It starts from page, my lord, 25. 14 representation, not a single line reply. It starts from page 25. Up to page 46. And with all datas, enclosures.
রেগে যাচ্ছ কেন তুমি আজকাল?
বদমাইশি করছে পয়সা কি?
রেগে যাচ্ছ আজকাল আজকাল তোমার
কোনদিন রাগ দেখেনি কেউ।
অভ্যাসগুলো খুব খারাপ হয়ে যাচ্ছে আমি দেখছি আজকে।
কোনদিন রাগি না।
হয়ে যাওয়ার পরে এসবগুলো আরম্ভ করেছে। আর মোর পার্টিকুলারলি তুমি আমার সঙ্গে আরম্ভ করেছো। তো বন্ধ করে
কৃষ্ণরের ছেলে।
একই জায়গার বলে এসব করবো না।
Kindly see the representation, not a single line reply for last 1 year. Why this hide and seek?
Petitioner is distributing ration articles to the end users through EPOS machine. Full stop. It appears to the petitioner that the closing balance appearing in the EPOS machine is dissimilar to the actual allocation received by him from the distributor. Finding such dissimilarity, he made representations with the authority concerned for rectification. The petitioner placed a number of representation to the authority, but none of his representation was considered. Furthermore, a specific direction upon the distributors have been made by the authority with the order dated 1st of June 2023 for supply of ration articles by adjusting the balance. It is the case of the petition that at present he is receiving more or less 20% less. He is receiving more or less receiving more than 20% less quantum of ration articles for every month.
Then the requirement, right?
Then the required quantity of the ration articles. Hence, they approach this court. Hence, he approached this court. Having heard the learned counsel for the parties, No, Kato. Mr. Suman Sengupta, Learned Counsel, appearing on behalf of the state, submits that the matter cannot be decided by this writ court without receiving any specific detailed report from the authority. Having heard the submission of the Learned Counsel, it appears to me that the matter cannot be disposed of without perusing the report from the state authority. Accordingly, the authority is directed to file a report on the form of affidavit within 3 weeks from date. A reply, if any, by the petitioner within 2 weeks thereafter. Full stop. Till that date, no, let the matter appear in the list.
But if your lordship is passing an interim order, then I will come up with the order and I will show. I have the instruction. Is specifically showed that there is an order has been passed. Lordship is talking on that point whether I have issued any order or not.
Yes.
In that event, if your lordship, I will request your lordship in that event, lordship kindly rest in for a moment. I will come back tomorrow and I will show the order. This has been, I have received this, but it is showing the annexure 9 is there, but I have not received the annexures with me. I can show to your lordship.
You can place the order on me also.
That is what I am saying.
Sufficient.
Yes, lordship kindly recall this order, or it is not required.
Okay. কি বললাম? Let the matter appear in the list. কি বললাম? Correct line দেবো। কাটো। কি বললাম last তারপর কি বললাম? Learned Counsel appearing on behalf of the কি বলেছে? Learned Counsel
tomorrow.
Authority. No, having heard the Learned Counsel. No, having heard the Learned Counsel for the
কি লিখছে যে ওনার ইস্যু করেছে?
না, accordingly state authority cut. The respondent authority is directed to produce the report with this court by tomorrow.
Very well.
Let the matter appear in the list tomorrow. Tomorrow.
ওইটা কত পড়েছে? হ্যাঁ, তখন বলবো। 41 plus 41টা কি হতো? 41টা কি?
Next.
Get load.
Lordship, I'm for the petitioner, Your Lordship. I'm seeking for an adjournment today, Your Lordship.
Not today.
Not this week, yeah, not
Not today.
Not today.
Siempre, Your Lordship.
Not today.
But similar matter, deduction, but separate district, Purva Medinipur, this is my affidavit of service. আপনি আছেন? 41.
42 আছে আমার।
So in this case, despite service since none appears, your lordship may give direction and well, same order may be possible.
Not tomorrow. It is. I have seen.
Purva Medinipur.
It can be day after tomorrow. Because
I don't have the determination. Day after tomorrow I will take
that
other matters.
No, in that
I will take up other matters.
No, I tell you, lordship, if I commit any promise to before your lordship, and if I fail, then it will be expedited.
আমি অর্জন করব। তুই বল, যদি পার চেষ্টা কর।
I will try tomorrow.
Otherwise Monday?
Yes.
Not
to appear. If not possible,
yes.
Similar direction. As of 38.
41 হয়ে গেল।
Same to 38.
কোনটা হয়ে গেল?
41 আর 38 একই অর্ডার।
Next.
Your Lordship, I am praying for not today. The Learned Counsel is for the petitioner is unable to appear due to some personal reasons.
Very well.
Much obliged.
Your Lordship.
Call the Passover matters.
Passover. First हमारी है। 4.
No one appearing, not this week. Next. Not this week.
Because you heard this matter, my learned junior placed the case on last occasion. The vacancy has been, there is a direction for taking instruction. Page 23, Your Lordship, kindly turn up. The vacancy declaring notice issued on 27th of December 2022 at page 23. But kindly see the Moradiki near Junior so-and-so, Tatpur Police Station, Rajinagar, Mouja jail number, Moradiki 120. This is very important. Mouja jail number, Moradiki 121.
Yes.
Then kindly turn to my lord, page 26. The newspaper publication published on 13 January by giving 21 days, serial number 24.
Yes.
I participated in the selection process by filing my application, which will appear from page 27. Within time, last date was 3rd of February, I have submitted 26th of January. The next date, I have been asked to present in my Shopcom godown, scheduled to be held on 29th March 2023 at 12:05 p.m. at page
29th March.
29th March 2023 at 12 p.m. Page 28. Well, on that day, inquiry could not be taken place. So next notice has been issued, page 29, fixing the date on 30th of March 2023. Then kindly turn up to my lord, page 42. No steps have been taken. I made 2 RTI applications. This is the reply to my first RTI application, addressing to the SPI Murshidabad ADC. Kindly see, my lord, how many applicants applied for. Kindly come to serial number 6 at page 42. The present condition of the new vacancy at Moradiki, near Moradiki Junior Basic High School under Belanaga so-and-so. This is my question. I am requesting you to be kind enough to furnish the information. Now, this has also been forwarded to other authority. Kindly come to my lord, page 43. The answer given by the subdivisional controller. State Your Lordship, kindly come to serial number 5. No, none of the candidates have been finally recommended for granting license against the said vacancy of fair price shop. As to query number 6, none of the 14 candidates have been recommended. The said vacancy is expected to be re-notified. This is by the subdivisional controller. Next page. Assistant District Controller, he is the much higher post. Kindly see the date, first one, page 43, 24th of September. And next one, 26th of September, by the Assistant District Controller. Query number 5, that the mentioned vacancy is currently under process. After 3 days. That the mentioned vacancy is currently under process. Kindly once again check the reply of both the authorities. The said vacancy is expected to be notified. None was found eligible by the subdivisional controller on 24th September, 26th September by the additional district controller. Proceedings is still continuing. Your Lordship knows.
Have you received any
nothing
of rejection or like that?
Nothing. What I am saying, so, if you Lordship kindly read one paragraph of my writ petition, para 19, page 19.
Yes.
Your petitioner states that your petitioner came to learn from the reliable source that the candidature of your petitioner has not been recommended since the Shopcom godown of your petitioner is not situated under the same Mouja as mentioned in the vacancy number so-and-so. Your petitioner states that the vacancy has been declared notified at village Moradiki near Moradiki Junior Basic High School, Datpur, PS Rajpur, Gumro so-and-so, Beranaga, and Mouja and jail number Moradiki 121 under Berampur subdivision in the district of Murshidabad. And the Shopcom godown of your petitioner is situated at village Moradiki so-and-so, Moradiki instead of, kindly read, my lord, only Mouja is different, 121.
Jail number is
Jail number. Kindly see, my lord. It is just beside the other side. Instead of Mouja jail number so-and-so, which is jail number Moradiki 118. So far vacancy is concerned, jail number 121. Both Moja and jail 121 vacancy has been notified. I am concerned, jail number 118, but Moja is 121. Now I read your lordship. Just besides the other side of the National Highway 34, which is 20 feet away from the advertised location. In this regard, it is pertinent to mention here that on introduction of doorstep delivery, distance location on showroom does not make any convenience or inconvenience to the consumers, since it is the duty of the fair price shop owner to deliver the ration articles to the doorstep of the controllers. Your petition states that in an identical matter being MT number so and so, state has affirmed an affidavit stating therein that on introduction of doorstep delivery under duration scheme, location of the showroom is immaterial. But same subdivisional controller affirmed an affidavit before the division bench. Kindly read, my lord. Copy though. Take up this affidavit. Same subject. Kindly see who has affirmed it. Shamol Haldar, paragraph 1. I am the subdivisional controller, Food and Supplies Department, Government of West Bengal, Borompur Sodor.
It's an affidavit before the
Division bench in a separate matter by the same subdivisional controller. Para 4, Roman 10, page 6. Running page 26. Have you lost got my Roman 10?
Yes.
It is stated that the size of the godown and shop room affected by an applicant for an paper is the most important criteria to adjudicate their suitability, to adjust their suitability. Other criteria like the distance of the shop room from the central point of vacancies are not that relevant in view of the fact that the paper shop dealers nowadays have to deliver the ration articles at the doorstep of the beneficiaries under the duration scheme. The appellant has the rural godown and shop room among also. It is the statement of the same subdivisional controller. It is immaterial location of the godown, since today duration has been introduced, and it is the duty of the dealers to deliver the goods to the doorstep of the consumers.
Yes.
My rejection, your lordship, on last occasion, directed I pray for an interim order. They prayed for an adjournment to take instruction. My specific case, otherwise, in all respect, I am the most suitable candidate. This side and that side, only jail number, not even Moja.
No, what interim order you want now?
Not to declare any vacancy, because all
They have not declared any vacancy.
kindly come to once again. The steps are being taken. Page 44, 43. Last. None of the 14 candidates have been recommended.
Or is saying that it is
Said
under
vacancy is
process.
expected to be notified September. Page 43. Page 43.
43 is
Query
the
number
vacancy
6.
is expected to be notified.
Yes, this is September. Now we are in January.
And 26 September, they say that it is under process.
Yes, the higher authority. For that reason, I am entitled to.
Millard, two things. So far these applications are concerned, there are 17 numbers of the Millard applicant was vacant. Millard, we could not find any of the person eligible. So thereby we have cancelled everything. Millard, whatever is their confusion or conflicting statement, Lordship cannot
There
go
must
by.
be rejection order will be there in the portal.
Portal, yes, of course, it is there. It is there.
It is there in the portal that your candidature has been rejected.
Yes, it has to be there. 17 number of the candidates has been come up. 17 numbers of the candidature could not been considered because this is a fair play in the joint.
Yes, yes.
So we could not find that any of the persons are suitable enough. So thereby we have cancelled the same. Now we have decided to go for a re-notification. So for the petitioner are concerned, petitioner is also unsuccessful candidate. He is seeking that since my godown is not falling within that moja, it is just adjacent
on the
jail.
jail.
Yes, adjacent to the same. Thereby, I am entitled. Lordship knows far better than I do. The Aram Shetty's judgment, whatever is there, it has to be followed in total.
Yes.
Even Mr. Sharai, I believe, has argued one point, and he has owned this point that this has to be followed in total. If today there are two moja or jail number called A or B, I have made
tender consideration has
correct.
to be there.
Correct. Whatever the condition is there, that has to be followed in toto. Ramanna Dayaram Setti's judgment. So therefore, my lord, the candidature which we could not be, attracted us. In fine, my lord, the 17 number of the candidates are failed. So thereby, at their behest, the new notification cannot be stalled at this moment. They have the liberty to apply. They have the liberty to apply. If they are falling within the zone of consideration, that can be considered. Otherwise, it will not. There is no, had it been a case, the 17 number of the candidates has applied and I have given a priority to any of the persons, that can be questioned.
Yes.
Can be arbitrary or be malafide. But that is also subject to the satisfaction of the authority, I would say. Here, the 17 numbers of the candidature has been cancelled. We could not find any of the person are suitable. The reasons are being given in the website. So, what is left in this petition? Today, my learned senior friend, I stand corrected, he may say there are two conflicting statements. One is by the ADC and one by the DC.
Yes.
Lordship do not go by that. I am submitting before your Lordship. Lordship can take my instruction, and this is also signed by the concerned department. So this is the all, Today, the 17 number of the candidature has been cancelled.
They have said 14 number of candidates.
No. So for our 13 applicants, sorry. 13 and one petitioner, that is the 14. I stand corrected.
14 applicants.
13 apart from the petitioner, one.
So total is 14.
14. I believe my learned senior friend has argued one point, that it has to be followed in the same moja, otherwise it cannot be given the effect to. I have to find out the judgment even. I have read the judgment, and this Ramanna Dayaram Setti's judgment, if your Lordship so desire, I can place the judgment. It is on 1979, 3 Supreme Court cases 489. Whatever there in the advertisement, it has to be followed in toto. We cannot give any relaxation. Had it been a case, we are giving any relaxation to any particular person. In that event, question of arbitrariness or the malafide comes automatically. That's all.
So notification is Moradigi 121.
Yes.
That is same. Moja is same.
And his godown is Moradigi 118.
Yes. Jail number.
Jail number.
Only jail number. Moja is same. My specific case I have made out, my lord, on last occasion I have also argued. That was the query of the court also. What is the ground for rejection? I don't know, my lord, in the report if that has been disclosed or not. I have placed a document.
The report was not placed.
Not placed, but he brought the instruction. As I understood, definitely, my lord, there is an whisper about my rejection. Why it has been rejected? I have the right to know why it has been rejected.
Yes, yes, definitely.
Okay, file the report.
Very well.
In the form of affidavit. Very well.
And dealing with this affidavit also, my lord, because I have handed over.
No, I will not. Definitely not. This has no. This has no relevancy. This has no relevancy with this vacancy.
Okay.
Vacancy may not have relevancy.
Whatever the law points are there, I will be dealing with the same.
The issue on the merit. Mr. Suman Sengupta, learned counsel appearing on behalf of the state, commits that he received the report. The authority concerned. The state is directed to submit the report in the form of affidavit within 2 weeks. Reply, if any, by the petitioner within 1 week thereafter. Let the matter appear in the list on February 11 under the same heading.
In the meantime, let
I'm
them.
opposing that interim
order. Ami ki chaichi there. Let them. They may proceed, but not to grant.
No, I am even opposing the same.
Okay.
You may oppose everything. That is every right. But if in the meantime, on a third party, okay. What I am saying, Let them proceed with the selection
Let-
process. But
This cannot be. He has no locus in that.
There are no selection process initiated.
Yes.
till today.
he is saying, he's saying,
We
proceed.
will.
Let
We
me
will.
see the report. I will pass the order.
Very well.
Shall abide by the order.
Yes.
Kindly record, my lord, that shall abide by the any steps taken.
Sahara nowadays become a senior advocate. He should not.
ভুল হয়ে গেছে।
Learned counsel, Mr. Sahara, six and interim order for stay of notification.
Stay of notification, my lord, not to proceed with the selection process.
Okay, for not to proceed with the selection process.
But we are not even to start.
It appears that not to proceed with any new selection process of the impugned vacancy. I find nothing in the record that any selection process was initiated.
Agree.
Considering the same, the order for interim protection is refused at this stage.
My lord,
All right.
get lords. ব্যাপারটা ব্যাপারটা ভালো করে ব্যাপারটা থাকবে না।
7 তারিখ 11th. It will appear on 11th, I guess.
Get lords.
Not this week.
Chairman, I am for the petitioner in this matter.
তেরোটা কি ব্যাপার?
My affidavit of service.
Yes.
My lord, the petitioner is extremely aggrieved, my lord, as there has been reduction of rationing articles for the month of June, July, August 2023 from the allotment of a petitioner. He made representation before respondent number 6, but there has been, my lord, no steps taken by them. For the state. The representation is in page 75 on 16th of April, but no such step. There has been a tampering of the EPOS machine, my lord, due to which there has been reduction.
Tampering of EPOS machine.
EPOS machine.
Who
my lord.
tampered?
Well, there is a the authorities have been intimated about it, but they are doing nothing about it.
Where is the information regarding tampering?
My lord, it's in paragraph 7, my lord. It has been incorporated into petition. Paragraph 7, my lord.
Paragraph 7.
7, 10.
7 of the writ petition.
Writ petition, paragraph 10 of the writ petition, my lord.
There have been tampering in the EPOS machine.
EPOS
due to
machine.
which there is a deduction. Who tampered the EPOS machine? Who tampered the
My
EPOS
lord,
machine?
there is a mischievous thing like the petitioner is not receiving those rationing articles in hand, but unfortunately her allotment is being deducted.
No, you are saying that there are some tampering.
Tampering going on due to which there has been a reduction of rationing articles from the allotment of the petitioner, which he has not received it physically. So there is some defect which requires a cyber experts to be
Receiving less quantity of ration article is separate issue. Tampering is separate issue. What you are
deduction of articles which he has not received in hand physically is my main contention, my lord.
your
And it-
contention.
yeah,
So
when-
there is no such tampering.
Tampering, my lord, there is a the
If
EPOS
there
machine
is tampering, there must have a police report. This is the government article.
Yes, my lord.
Whether you have informed the police regarding
No, my
tampering,
lord.
who tampered? This is the government article. What is your prayer?
Prayer, my lord, to consider representation dated 16th April 2024, my lord.
Page.
My lord, the representation is in page 75, my lord.
Page 75.
75 of the writ petition.
So in your representation, you have never said about the tampering. You are receiving less quantity
Yes,
of
my
the
lord.
articles. But the stock appearing in the EPOS machine is
to-
higher.
Higher. That is the main contention.
That is their contention.
Read this.
Yes.
Well, the tampering, we have taken instruction on that. This is at a absolute.
No, he is not basing on the tampering.
And during regarding the reduction of stock, my lord, I'll have to take instruction.
No, he only want some his representation may be considered.
Considered. It's okay. Considered.
Please take down. Petitioner is a ration dealer distributing ration articles to the end users, to the beneficiaries. Full stop. It is the contention of the petitioner that he is receiving.
She, my lord.
He is receiving less quantity of ration articles than it appearing in the EPOS machine. Since the February 2022, he made several requests to the concerned authority for correction of such dissimilarities appearing in the EPOS machine. Finally, he approached the authority with a representation dated 16th of April 2024 within bracket annexure P5. The concerned SCFS has not considered the same. Thus, he approached this court. Having heard the learned counsel for the parties, it appears to me that the present petitioner, being an EMA dealer, is suffering regarding the dissimilarity appearing in the stock appearing in the EPOS machine as well as the physical stock received from the distributor. The same issue can only be determined by the concerned SCFS. Accordingly, the instant writ petition is disposed of with a direction to the SCFS to consider the representation of the petitioner appearing in annexure P5 of the writ petitioner within 6 weeks from the date of receiving of the intimation, receiving of the copy of the order of this court. By passing a reason order. The next part, the concerned SCFS shall give the reasonable opportunity of being heard to the petitioner before disposing of the same and shall intimate his decision within 2 weeks thereafter. I make it next. I make it clear that this court has not entered into the merit of this matter. The authority concerned is at leave to dispose of the representation according to law. Full stop. Next para. The according to law. Next para. As affidavits are not exchanged, allegation made in the writ petition shall be deemed to have been not admitted. Affidavit of service filed on the petitioner is taken under. Next. Oh, noted. কি আছে
This matter, my lord, appear on behalf of the respondent, but my lord,
Item number 11.
Which matter?
item number 11, my lord.
Yes.
As I find, my lord, a report is required to be filed disclosing all the documents because
List item number 11.
number 11.
You are for the state
I
authority.
for the state, my lord,
What is your
I am
prayer?
for the petitioner, lordship. The petitioner applied for the getting the new license. Via the notification, lordship. One vacancy notification has been issued. The lordship will find from page number 34. Upon which lordship the petitioner has applied for the getting the license in subject vacancy declaration, lordship, and subsequently after that application, lordship, that has been admitted and inspection has been conducted. Lordship will find from page number 38, lordship, that the inspection which has been conducted on 11th June 2024. After that inspection, lordship, that petitioner was waiting for prolong that what is the decision after the inspection whether he is eligible to get the license or not, lordship. He was awaiting for his turn. Now, lordship, subsequently during this pendency of the entire proceeding, lordship, on 17th of September, lordship, the petitioner has made a representation before the concerned authority asking for the expedite the procedure of giving the license to the petitioner. And subsequently, lordship, what happened, lordship, the petitioner came to know that his application has been rejected without citing any reason, lordship. Now, what is the reason behind it for the rejection, lordship, that is not known to the petitioner.
First of all, my lord, fate of the application can be verified from the website, whether rejected or not.
That I've already declared, it has rejected.
Rejected.
It is
Because
rejected, Lordship. It is
that
added.
does not fulfill the eligibility criteria even. It doesn't have any go down. Even if something is
If you
there,
if you want to file the report,
So
I
why
want
the
to file the
inspection has
report
been
based on
conducted?
the inquiry report, what has been found,
very well.
and was the best possible opportunity to has been given to the petitioner. I just wanted to show before your lordship by way of an affidavit.
Please take down.
And in the meantime, Lordship, that no, Lordship, that
How can you stop?
let
Having
them
heard
come
the
with the
learned
report
counsel
within
for the party, it appears that the instant writ petition can only be disposed of on exchange of affidavits. Let the state authority directed to submit the report in the form of affidavit within 2 weeks from date.
Lordship.
Reply if any by the petitioner within 1 week thereafter. Let the matter appear in the list on February 18th. Full stop. Under the same heading. February 18th.
Under the same heading, Lordship.
Yes, under the same heading.
And grateful to your Lordship.
নম্বরটা প্রথম। My clerk is so vigilant. He told me, see order in your matter. It's a second matter. It's a second matter. I didn't know that. He just told me.
কোনটা রেডি আছে না রাখুন পাশেরটা রাখুন
হ্যাঁ May it please, Your Lordship, my lord, I'm appearing for the appellant. Lord, I'll be very brief. Now, my lord, there are 3 points on which, my lord, I will make my submissions.
So with the leave of my senior friend, on the last occasion, Mr. Chaturvedi, who was leading me in this matter, had informed your court that there's an
Order passed
by the Honorable Apex Court,
which was referred before the division.
The entire section 14 has been referred. Now,
14.2.
The order says that it is the interplay of 14.1 and 14.2 which is being referred, but the wordings are that section 14 has been referred for interpretation. So what, subject to my studied senior friend and my lord's consideration, was that in the event my lords is still minded to proceed with the matter, because that's what we also want to, and my lords can at least have a look at this order and then maybe decide, because we don't want to come trouble your lordship, and at the end, maybe when we place this judgment, then my lords may be minded to
Whether the issue of law
Lordship.
regarding the
lordship.
determination of this matter is involved in
We
on
say
an
no.
appeal.
We
What
say
are
no.
your consideration? What is
this,
your view?
This order, I will indicate, is my last point. That's my last point. I understand what is falling from my learned friend. In fact, that is the judgment which I am also carrying, Tej Ban, where, my lord, this has been referred to a larger bench, 14.1 and 14.2. My point is very different. 14.1, 14.2 will be touched upon, my lord, because that's the other issue. If your lordship recalls, I'll place it broadly. I'll put it in my notes in details, but I'll place, my lord, why I'm making this submission. Kindly give me 10 minutes, because if I want to indicate, I have to indicate the judgments on the different propositions which I'm carrying now today. I'm all ready to finish it, my lord, because this is a point which is very, very interesting.
I am also ready today.
I understand that, my lord. And that is the reason, Lord, your lordship has fixed the
If it
matter.
is come under the way, the order of the Honorable Apex Court
My
to
lord,
decide this matter,
it
then
has.
I shall not proceed.
14.1, 14.2 will be a point which will fall for consideration of your lordship.
Then I shall
But
not
before
proceed.
that, my lord, before that, even without that, that is the reason I said, my lord, this is my last point. Kindly give me 10 minutes and I'll indicate why this is my last point. If then your lordship feels, my lord, that your lordship will not go ahead, then it can be adjourned.
Yes, you can proceed.
Very briefly, my lord.
Yes.
Lord, first and foremost, kindly take up the plaint, the amended plaint.
নোটস কোথায় নোটস কোথায় নোটস গুলো ফাইল দেখে না আরো ফাইল আছে
Where is the other icon?
Yes.
There are 2 things are very relevant in the present proceeding. 1, the amended plaint, and 2, the appellate court's order. Because that has, my lord, the judgment and decree has now merged into that order, the appeal court's order. In the amended plaint, my lord, your lordship will not find the word thika used at all. Very interesting, my lord. Why is it that in the plaint it has not been described as a thika property, but in the course of submissions it was conceded that this Rakhal Das Audi Road was a thika property, but not in the plaint.
In the plaint or amended plaint, there are nothing.
There's nothing with regard to thika property. In fact, my lord,
That is 32A Rakhal Das Audi Road.
My lord. And kindly note the prayer. It's a conjoint prayer. It's not that a separate prayer for the thika property, separate prayer for. It's a conjoint prayer, page 6, a decree for partition, declaring that plaintiff's 1/3 share in the suit premises properties mentioned in item 1 and 2 of schedule below. Now kindly see how the schedule describes these 2 properties. So this is page 6 of the amended plaint. Lord, I'll indicate. broadly, my lord, why this is what I'm arguing.
Give me the LCR, LCR.
You have an extra copy of the plaint, amended plaint?
Yes.
You have the amended plaint. In the pleading, nowhere has it been very, very cleverly done. This is for bypassing the bar under section 21 of the Thika Tenancy Act, and I'll indicate why. In the pleading, your lordship will not find a whisper with regard to 32 Rakhaldas Odi Road being a Thika property. Now, if your lordship kindly takes up the prayer. We need to make copies of this. May I hand over my copy, my lord? Fine. So my iPad. Your share inside. Take from my iPad because my iPad has a provide
Yes.
Now, the first point is there's no whisper of this being a Thika property in the pleading. I mean, the prayer, the first prayer is partition, which is permissible. Second prayer is to give effect to that partition, not permissible. And I'll show from judgments why this is not permissible. And hence, they have a permanent ad interim order of injunction. Nothing described what exactly they want. Now, kindly see the schedule. They describe both the properties together, not as a Thika property. In the prayer A, 1/3 share in the suit properties mentioned in item 1 and item 2 of the schedule below.
Yes.
Milord, this prayer is a conjoint prayer. If, Milord, this prayer could not be made for the Thika property, it could be made for the other property, not for the Thika property. Now, Milord, a suit, if it's to be rejected on a point of law, Milord, it has to be rejected in whole. Absolutely same case, Milord. I'll first contend the proposition of law which, Milord, I'm now going to argue and advance judgments on.
In the written statement, you have said it is a Thika property.
We have said it's a Thika property. That's our stand. We are not the plaintiff. They are the plaintiff.
I understand.
Milord, we have stated it's a Thika property. They have conceded and they have also stated, yes, it's a Thika property, which is recorded, Milord, in the judgment and decree, which is also recorded in the appeal court's order.
But in the plaint for amendment, there is nothing.
The reason is, Milord, had they made this pleading, there would be a bar under 21. And 21 kindly take up with 5(3). Milord, 5(3), may I first read out of the 2001 Act, West Bengal Thika Tenancy Acquisition and Regulation Act, 2001. 5(3), incidents of tenancies in respect of lands vested in the state. 3 says, if any question arises as to whether a person is a Thika tenant or not,
yes,
whether the land in question is a Thika land or not, the controller, either on his own motion or upon receiving any information, may, after giving the persons interested an opportunity of being heard and after examining all the documents and particulars as may be considered necessary, inquire upon and decide such question. This issue was taken by us in the suit. While the suit was being heard, this point was raised of maintainability, that this cannot be adjudicated by the civil court. Once they had admitted that it's a Thika property, this point was raised. Three judgments, because section 21 is a clear bar then?
Yes.
Section 21 being a clear bar, it draws from 23 of the 81 Act. Three judgments of this honorable court, my lord. One is a 2019 judgment in Sagira Banu versus Muhammad Alam. May I hand over, my lord, the soft copy? My lord, will annex the hard copies to, my lord, the note. Sir, I have a soft copy. Shagira Banu versus Muhammad Alam. It is reported in 2019, volume 5, CHN 504.
Yes.
My lord, 5.3 is set out in paragraph 6. It was, my lord, when the court was deciding Order 7, Rule 11, a demurrer on this point. Paragraph 2 sets out the facts. I'm not troubling your lordship with that. My lord, paragraph 7 is the finding. In other words, all incidents of Thika tenancies to be determined by Thika controller, no civil court will have jurisdiction to decide with any such matter which is required to be determined by the controller. Enumerated in section 21, in the present case, they prayed for a decree of declaration that the defendant had no right, title, interest over the disputed property, decree for injunction against the defendants. Plaintiffs claimed their title and possession in respect of property as Thika tenants. We say, my lord, it's a Thika property, hence you cannot touch upon it. State was not made a party. Points taken in argument, my lord. Judgment referred to in paragraph 9 and kindly see paragraph 10. Though the dispute between the parties apparently seems to be that of title adjudication, as to whether the plaintiffs are occupying property as Thika tenants comes into play, and such adjudication which forms the moot point in the case is barred by 5.3 as well as 21. CO allowed. Now, my lord, with this, kindly take up the next decision. And I'll indicate from the facts also, my lord, I've stated that this point was taken and it was decided. My lord, we had raised this objection. It's not for the first time that we are raising this objection in the second appeal. My lord, kindly take up the next decision. May I take it out for your lordship, my lord? The next decision. Let me know when 21 is taken up. Tell them. Take it. So the next decision, may I hand over? 2016. Suchita Ruia versus Vikash Fabrics Private Limited. It's reported, my lord, in 2016, volume 3, CHN 376. Again, in Order 7, Rule 11 being decided, my lord, by the court. Paragraph 8. The section is set out. 8 and 9, my lord. 8, the section is set out. 9, the contention of 5.3 is, my lord, recorded. 11 is, my lord, the findings. After hearing the rival submissions of the parties, I want to go through the impugned order itself again. Speaks on perusal of the defendant's application, Order 7, Rule 11, objection filed. Considering submissions, I am of the view no such statement in the plaint which renders this is barred by law. Further opined, plaintiff in person is not hit by provisions of Order 7, Rule 11. That was not what was under challenge. My lord, paragraph 13 onwards is, my lord, the discussion. And 14 This my lord, a meaningful reading of the plain discloses the fate of the suit hinges upon the status of the opposite party, that is Thika tenant. That's, my lord, also our case. That the entire fate, because, my lord, this property otherwise can't be partitioned and, my lord, effect cannot be given into. And paragraph 16, my lord, reiterating the same point, that if it touches upon this issue, 5321 becomes operative, civil court will lose jurisdiction. Now, the most important judgment on this line, my lord, which I'm going to refer to, that Prabhas Aich, it's a 2017 decision. It is reported in 2018 volume 4 CHN 74. Let kindly take up paragraph 22 onwards of this judgment. Decisions are referred to in 22, my lord, 22, 24, 26 is the finding. Kindly take up paragraph 26. I'll not trouble your lordship with the. It's also, my lord, where the court was deciding a petition under Order 7, Rule 11, 11D. Paragraph 26, my lord.
Yes.
The proposition of law enunciated in the aforesaid two reports are that normally the suit for declaration of civil rights is maintainable before the civil court, unless jurisdiction of the civil court is barred by law expressly or by necessary implication. See section 9 of CPC. The court shall confine its scrutiny in an application for rejection of the plaint to the averments made in the plaint and by documents disclosed along with it to ascertain whether the suit is otherwise barred by law. The court should not look into other materials or the averments disclosed by the defendant either in the application under Order 7 Rule 11D or this. By a meaningful reading of the averments made in the plaint, it leaves no doubt that the same is barred by law. It is imperative and mandatory for the court to reject the plaint. Court should not reject the plaint if the other reliefs which are independent and separable from the first relief. This is very important, my lord. I'll indicate why. As law does not permit partial rejection of the plaint. Also, in a case where the court has to make a hovering scrutiny and interpretation of the various documents are also facts gone into, it would not be proper to reject. This is on the point of Order 7 Rule 11. Now, the next paragraph, reverting back to the factual matrix of this case. Primary relief claimed in the plaint is a declaration for the purported gift of deed as invalid, inoperative, and void. And the relief in the form of partition and separation of shares takes a backseat and depends upon the decision taken in the main relief. But here the facts were that there was a gift deed. Through the gift deed, a Thika tenancy was being disposed of. That was the allegation. The defendant said it's a Thika tenancy, you can't make a transfer through a gift deed. Declaration in the plaint of the prayer was for declaration that the gift deed is valid. And second was, my lord, to give effect to that gift deed. And consequential reliefs. Here, my lord, the court held that if it touches upon, if the prayers are the same, it comes out of a same cause of action. Then you can't separate it. One is not maintainable, the second has to, my lord, go. The court will not have jurisdiction to, my lord, take up one for consideration and give up the other. So here, if it is admitted, my lord, that this is a Thika property, the court cannot, my lord, and there was also no prayer. That's why, my lord, I started with the prayer. It's not that the two properties are separately prayed for. It's one prayer for both the properties. Now, my lord, kindly see the next paragraph. Though the civil court is competent to decide the case relating to partition and separation of shares, Yet the aforesaid reliefs being dependent one, particularly depending upon the issue of validity and invalidity of the deed of gift, the court finds that the plaint as stands as a whole cannot stand in the eye of law. Here, my lord, the part which relates to, my lord, the tenancy is valid. But, my lord, the other part, it's not a mere, my lord, declaration that they want. They want a decree for partition. They want to give effect to that decree. That effect to the decree cannot be given because of 5.3. It has vested. If it's a Thika property, my lord, that's an admitted position now. It's there in the appeal court's order that it's a Thika property.
Yes.
It is on their concession that this recording was made. That's a Thika property. If it's a Thika property, rest of it, my lord, goes out of the ambit. Because then the court will not bifurcate, my lord, to hold a part of the suit as maintainable and the part not maintainable. I'm just broadly indicating, my lord, this is my next judgment because here, my lord, it's stated you can't bifurcate it and Order 7 Rule 11D was allowed. The suit was not maintainable. Touches upon, my lord, 5.3. Therefore, my lord, if I take it that this is a suit merely for a declaration and for nothing else, because the consequential relief is not maintainable. The effect to the partition, my lord, through a commissioner, that's not maintainable for a Thika property. Because then it has to be decided. That decision-making process by 5.3 is with the controller. And the suit was never maintainable. Point taken by us, held against us. I'll refer to two decisions, my lord. I should put my learned friends on notice. With regard to declaration, basic principle, my lord, bare declaration without any consequential relief or possession, other reliefs, not permissible. I'm going to develop the argument to the extent that if the subsequent consequential prayer is not maintainable, the primary prayer will not be maintainable. Can't be bifurcated. If the consequential prayer is illegal, the first prayer has to go.
Yes.
That's my next proposition. Two judgments on that. But before that, since my learned senior friend has also raised this issue, is stage ban, may I take up? In fact, there are two judgments. I've brought both. One is Kallakuri, which was, my lord, passed, I think, 2 days before the next judgment by Supreme Court. Kallakuri, my lord, I'll take out Kallakuri for your lordship. Kallakuri. My lord, Kallakuri, it's 21st November 2024. At the end. This is, my lord, kindly take, I'm not troubling your lordship with the entire analysis. I'll quickly take your lordship through what this judgment is. My lord, this judgment is a conjoint reading of 14.1 and 14.2.
Kallapuri.
It's there. We have a printed copy also. My lord, I'll also hand over a printed copy which I have.
That is better.
Your lordship may, my lord, follow from, your lordship may take that up because I've marked the parts. My lord, this will.
So tell me the paragraph.
I'll tell you, your lordship, the paragraph. Paragraph 3 are the facts. It starts from the trial court's issue is 3.8. 3.8 is trial court's issue. 3.9 is the reasoning summarized. I'm not troubling your lordship with the details. I'm just indicating, Lord, where this is. High Court's decision in paragraph 4. And then the issue before the Supreme Court in paragraph 6. Paragraph 6, the simple question in this appeal is whether the appellant defendants are entitled to the entire property in line with the position that Shri Veerabhadramma, by virtue of Hindu Succession Act 1956, would have absolute rights over the suit property, subject property, and therefore would be able to bequeath the same by way of will to her successors. So 14.1, our case is not 14.2 at all. Our case is 14.1. Now 14.1, whether at all is applicable. Because 14.1 says what? I'm asking this question to myself. 14.1, it's set out in the next paragraph.
Yes.
Any property possessed. Kindly encircle this word possessed. This is my case. It was never possessed. My case is this. Possessed by a female Hindu, whether acquired before or after the commencement of this act, shall be held by her as the full owner thereof and not as a limited owner. Your Lordship will bear recall, my Lord, the possession was to the limited extent of being a guardian to the minor sons. She was never in possession. I could not have argued this case in this manner, my Lord, had the plaintiff been in possession. Plaintiff was never in possession. Plaintiff, in fact, my Lord, is asking for rents because the property is tenanted. So the plaintiff has admitted that the plaintiff was never in possession. The way the plaintiff is claiming is that the plaintiff's mother was in possession before she, my Lord, left for heavenly abode in 1976.
Your argument is plaintiff mother was not even in possession.
My argument is even plaintiff's mother was not in possession. She was, my Lord, taking care of the property, which was in fact the property of the minor sons. And not as a maintenance. My Lord, that is a different issue altogether. That was never an issue, my Lord. So if the property was in lieu of her maintenance, that's a different issue. Because here, my Lord, the essence of 14.1 is the property should be possessed. That possession was never there. And with the plaintiff admitted possession, she did not have the possession. That's an admitted position, my Lord. 14.2 in any way will not apply to our case, my Lord, because that is by way of gift or will or any other instrument. Here, that's not the case.
Yes.
Now, paragraph 8 says, my Lord, for ample clarity is to be stated, appellant defendants favor the application under 14.1, whereas plaintiff respondents favor application of 14.2. Law discussed, the operative portion is paragraph 10.
Yes.
What flows from the above is that the Hindu woman's right to maintenance is not by virtue of statute, but is found in Shastric Hindu law. Maintenance has to be proper, appropriate, adequate, giving the woman so maintained the ability to continue to live the life similar to what she once lived. That's maintenance, my Lord. Not our case. And that the very right to receive maintenance. So that is on maintenance. Now the facts were discussed in the next paragraph. Kindly take a paragraph 12. This is the only paragraph which is relevant thereafter. And I'll distinguish this judgment, my Lord, from this paragraph, paragraph 12. The law is laid down in Gulwant Kaur and confirmed in Jaswant Kaur, paragraph 12, my Lord. Is clear. Property given in lieu of maintenance would solidify into absolute ownership in 14.1. That's not the case. That is not the pleaded case also in the plaint. In the amended plaint, that's not the pleaded case. Property given in lieu of maintenance would solidify into absolute ownership. In other words, right of maintenance on its own is apposite for such property to transfer into sole, unquestionable and absolute right. Partition deed of 1933 held clearly this. A mere pleading, because in lieu of maintenance, how is it to be proved? It has to be proved in trial. Mere pleading would not, my Lord, be of any assistance to my learned friends. One line in the suit, I should indicate that, page 3, where, my Lord, they have described 41 Shankar Bose Road.
Page 3 of the amended plaint.
Amended plaint, my Lord. Kindly see, my Lord, the last line at page 2. For argument's sake, even if the husband of the said Bhutimoni Dasi, that is father of the plaintiff, namely Kalicharan Das, since deceased, was the sole and absolute owner of 41 Shankar Bose Road, the mother of the plaintiff, said Bhutimoni Dasi, has got the right to maintenance and pre-existing right which existed under Shastric law, Hindu law, and was in possession of the premises number 4/1 Shankar Bose Road of her husband. This is not the Thika tenancy property, Minor. This is the property which is tenanted. So 14(1) then has to be argued at the max for this property. Now, my lord, comes the judgment in Tejban, where this entire part of 14(1) and 14(2) has been doubted, which my learned senior friend also indicated. My lord, I'll hand over a copy of the judgment. Tejban. Yeah, I have it. Now, the first paragraph makes for an interesting read, my lord. Interpreting section 14 of the Hindu Succession Act in Tulasamma versus Shesha Reddy, Justice Bhagwati observed that this is a classic instance of a statutory provision which, by reason of its inapt draftsmanship, has created endless confusion for litigants and has proved to be a paradise for lawyers, raising concern about the legislative indifference and interpretive difficulties presented by subsections 1 and 2 of section 14, leading to judicial divergence which might as well be described as chaotic, robbing the law of the modicum of certainty which it must always possess, Justice Bhagwati observed, and its plot set out, quoted. With this trepidation, they proceeded to resolve a confusion surrounding interplay between 1 and 2 of section 14. But I'm not troubling your lordship, I'm only indicating, my lord, in paragraph 2, the next page, first line, second line, my lord. This is page number 3 of the judgment, second line. While the first applies principles of Tulasamma as a inviolable principle, steadfastly holding that the property possessed by a Hindu female before or after commencement of the act shall be held by her as full owner. The other seems to be evolving from case to case, influenced by 1, 2, and 3. Method and manner by which Hindu female is possessed. 2 is the instrument to which the right is acquired. 3, the time at which such possession takes place. Having gone through the precedents in details, our endeavors to reconcile the judgments and restate the principles. However, in view of the fact that we are a combination of 2-judge bench, such exercise will not be fruitful, as our judgment will be subject to the decision of many 3-judges benches which need to be reconciled. I'm not troubling you, lordship, with the rest of it, my lord. Kindly take up paragraph 17. 17 is one stream of, my lord, judgments quoted.
Yes.
Paragraph 17 is one set of judgments following Tulasamma, my lord. Paragraph 18 is the other set of judgments following Karmi. That's set out. And thereafter, my lord, since the contrary principles were laid down, paragraph 22 onwards. It's important to note paragraph 22, my lord, page 18.
Yes.
Paragraph 22, my lord. It is important to note that except Karmi, the decisions in Bura, Gumfa, and Sadhu Singh are all by 2-judges bench. Larger perspective in which section 14 was interpreted holistically commenced from Karmi and was followed in many subsequent cases. Some of the decisions in the same line are Gadam Ramakrishna Reddy, Jagan Singh, Shivdev Kaur, Ranveer Devan, and Jogi Ram. We have noticed that the following Tulasamma, the subsequent decisions have made passing observations about discordant note in the case of Karmi, Bhura, and Gumpha, but they have not been clearly or categorically overruled. Perhaps this is the reason why the subsequent decisions consistently followed the idea in Karmi and enunciated different principles in the subsequent decisions. At that perspective continued its own strength. And then paragraph 24. Having realized that there are a large number of decisions which are not only inconsistent with one another on principle, but have tried to negotiate a contrary view by distinguishing them on facts or by simply ignoring the binding decision, we are of the view that there must be clarity and certainty in the interpretation of section 14 and paragraph 25 referring to, my lord, the larger bench. Now there lies the difficulty, my lord. Today, my lord, I concede to what my learned senior friend has submitted, that with this judgment, my lord, touching upon the issue, although my main issue is something else, my lord, Thika, it cannot be maintainable. I have prima facie described, my lord, indicated, canvassed my submissions to highlight that this suit itself is not maintainable. Because if I take out prayer B, then, my lord, only with prayer A, I have two judgments. Mere declaration, my lord, specific relief act, section 35, 42 will be hit, because otherwise, my lord, then there will be no consequential relief. Consequential relief is bad in law. Today, my lord, while conceding to my learned friend's submission that this matter should not be proceeded with in, my lord, view of this observation and reference to the larger bench, today before, my lord, appearing in the matter, in the lunch break, I've checked whether there is a further development, my lord, to this decision. It is not, my lord. It is listed somewhere. It is still pending, my lord, the final hearing. So may I make this prayer, my lord? Since this is the situation, if this second appeal, my lord, if the order which is, my lord, in appeal impugned before your lordship, it is, my lord, not stayed, then, my lord, we are in difficulty. My lord, also I understand that this judgment, my lord, after it is referred to the larger bench, there is a grey area in 14.1 and 14.2. Yes. Which I understand your lordship's difficulty, my lord. If today there's, my lord, it is held this way or that way, my lord, your lordship will, my lord, find it difficult. I understand that. I am making this prayer, my lord, that till then, till, my lord, this decision is, my lord, rendered by the Honorable Supreme Court larger bench, but kindly stay the impugned order. And, my lord, may we come back and mention when, my lord, with liberty to mention whenever this is decided.
What order you want to stay?
My lord, kindly see the impugned order. This is the impugned order in appeal, my lord, is essentially allowing the suit.
Is there any requirement of passing any interim order like that?
My lord, in the light of this situation, my lord, perhaps there is. Can you see the ordering portion, page 45? Set aside the appellant's plaintiff's 4/9 share over the suit property is hereby declared. Parties are hereby directed to get the partition by meets and bounds within 3 months. This is the reason, my lord.
In the second appeal, you have got the stay, I think? No.
We have not. That is my instruction. There is no stay, my lord. Is there a stay, sir?
My lord, kindly, my lord, comes to the paper book.
Page?
My lord, kindly comes to page 65.
Yes.
My lord, the appeal will be heard on the following substantial questions. My lord has very kindly go.
Yes.
But then kindly turn over the page. And kindly, my lord, come to page 68.
Yes.
Lord, kindly sees the last but one paragraph. During the pendency of the appeal, the learned judge in the court below shall be free to proceed with the final decree.
But yes.
But he shall not pass the final decree without the leave of the court. This is an order passed by the...
May I only pray for one clarification to this, not one addition to this? Show me the order. My lord, since it is indicated during the pendency of the appeal, learned judge in the court below shall be free to proceed. I am only praying should not proceed till this is decided. The reason, my lord,
decided, no, let it be decided, let it be proceeded, but final decree shall not
but
be.
since they have not proceeded for 10, my lord, 15 years now.
So what is the purpose?
So, my lord, kindly pass that one line order which will not prejudice us but my lord will be safeguarding us. Today, my lord, we'll have to again, it will be a my lord satellite proceeding again. Again, we have to my lord proceed there because today this is the direction which stares at us. That is the only reason I wanted to my lord make this submission. Had I not
Nothing
my
is
lord,
stare upon you. Nothing is stare upon you. Final decree has been stalled.
my lord,
That
it
is
has
the
not
issue.
really been stalled because my lord, kindly see my lord how it is recorded. During the pendency of the appeal, the learned judge in the court below shall be free to proceed with the final decree proceeding, but he shall not pass the final decree without the leave of the court.
Drawing of the final decree.
Indeed,
That it will not drawn.
may I only pray for one clarification here then. Till my lord, this since my lord today, otherwise I would not have opened the matter. The only reason I opened the matter is to show my lord and canvass my
No,
submission
what
that
is
we have
the
a
what is
prima
the
facie.
what is the status? What is the status before the court below? Whether commission was appointed, whether any decree was
They have not allowed the advocate commissioner to visit the property.
then everything
He has
is
been.
That's a grave allegation. My lord. They have not allowed. I do not know really because I don't have instruction.
Let him complete. I have documents to show. I am not saying it from my cuff. If he has completed, my lord, I would start.
Yes.
হয়েছে, প্রণীত, বলা হয়েছে? Have you completed?
2 minutes, sir.
Please.
My only prayer, my lord, I'll rest my submissions thereafter. My
Yes.
only prayer is this. Since, my lord, if the matter is not proceeded with, I have shown from judgments that the suit itself was not maintainable. On that prima facie, my lord, submission, my prayer is, my lord, to modify the order of admission, where my lord, my lord, direction was given to the learned judge to proceed with the final decree. My lord, may that be stayed. Otherwise, my lord, I would not have made all these submissions. I would have conceded, I would have come back, my lord. The only reason, my lord, why I wanted to show these judgments and I wanted to indicate this is to meet, my lord, to be able to make this prayer.
This is the regular order.
It is, my lord. But in the fact of these circumstances, my lord, this is not a very regular circumstance, my lord, that a larger bench, my lord, will decide and the matter will be pending till then. The only difficulty, my lord, it will loom large over us.
No,
Today,
I understand you may have your merit in the matter,
my lord.
but the appeal, second appeal cannot be decided at this
I understand.
stage. You
That is the
understand,
only
right?
reason, my lord. I'm seeking
So
only
how
one
can
line
I-
order from
how
your
can
lordship.
how can I proceed with the admission order of the admission?
No, my lord, I'm not. I'm only praying that, my lord, since this is the difficulty, my lord, we are all faced with. Lord, may there be one line clarification that till then, my lord, till this is decided,
What difficulty you are facing?
Lord, it is looming large over us. It may, my lord, it may come back to haunt us any day. Today, my lord, if this is proceeded with, my lord, very seriously by the plaintiff, my lord, then this will loom large over us. It will be, my lord, like a Damascus sword over us, my lord. That is not something we want. Now, I'm instructed that dates are, my lord, there are dates in the lower court, where, my lord, there are substitution. Proceedings are happening, my lord, in the lower court. It's not that, my lord, nothing is proceeding with. My only prayer, my lord, till this is decided, my lord, let there be a stay, my lord. The learned judge should not be, my lord, directed to proceed. Only this much, my lord. Only one liner. That's all that I'm praying for.
Hard.
I'm very deeply obliged, my lord, for the patient hearing. Very deeply obliged.
Yes.
But, if my lord would hear the appeal on merits, then my lord, appearing for the respondents, my lord, I exercise my right to make an opening submission that this second appeal does not involve any substantial questions of law. This right, my lord, under the amended provisions of section 100, my lord, has been protected and has been recognized in a very celebrated judgment, my lord, of Santosh Hajari, my lord, which is reported in AIR 2001.
Yes.
And this position, my lord, has been, my lord, reiterated until 2019 by the Honorable Supreme Court. My lord, I shall cite judgments. Now, this is, my lord, if my lord is, my lord, willing to hear the appeal on its merits, means taking forward the hearing of the appeal from the order of admission. Lord, I showed to my lord, but the order of admission, my lord, categorically specifies the issues on which the appeal would be heard. And during pendency of the appeal, how the rights of the parties would be protected. That order governs the parties as of date. There are those some developments, my lord, which, my lord, I need to apprise my lord, since an adventure has been made by my learned friend to seek a modification of the order of admission passed by an honorable division bench. To carry forward the order of admission, the learned court below, my lord, appointed an advocate commissioner who went, my lord, to the premises. He was obstructed. He sought for police help. During the pendency of this appeal, my lord, the property was developed, flats were constructed, flats were being let out. At that stage, we took out an application. An order of injunction was passed. That order was violated. We filed, my lord, an application seeking implementation of the order of injunction passed by this honorable court. This honorable court appointed an advocate commissioner. So this is, my lord, if an appeal is a continuation of the proceeding, then this is a second advocate commissioner, my lord, simultaneously appointed, one for giving effect to the order of admission, and second to another order in the self-same proceeding. Now that after the appeal is, my lord, heard, is admitted, it is being heard by or before an honorable single judge, and the honorable single judge passing an order of injunction. But this honorable court, my lord, a coordinate bench, my lord, appointed an learned advocate commissioner to visit the property. My lord, learned advocates for the parties accompanied the commissioner, and neither the parties nor their advocates, my lord, nor the learned advocate commissioner was given access. He has filed a report in my lord's court. The report is in my lord's brief. That is, my lord, the conduct of the appellant before my lord at this juncture. Now my lord can understand, my lord, as to what prejudice the appellant is apprehending during the pendency of an appeal, which my lord is in the process of hearing. My lord has painstakingly taking notes, my lord, of submissions made by my learned friend, and had this judgment of Tejwan not come in the way, possibly my lord would have not concluded the hearing. So, my lord, in so far as the prayer for a modification, my lord, I say that one, that there is no requirement. Two, that the order of admission sufficiently protects the right of the parties and has been permitted to continue for the past 15 years. We are at a penultimate stage when the appeal would be concluded of insofar as the hearing is concerned any day. And Tejwan, my lord, is standing in the way insofar as all the judgments which have, my lord, largely relied upon on either 14.1 or 14.2, including the one, my lord, which has been passed 2 days before Tejwan, has also been referred to in Tejwan. Now, irony is, my lord, as the commencing paragraph of this Tejwan's judgment, my lord, has seen,
Yes.
Tulsamma.
Yes.
Tulsamma is a 3 judges bench judgment. And Tulsamma in paragraph 62, my lord, says that irrespective of the fact that the deceased did not have actual physical possession, a constructive possession will also subserve the purpose of 14.1. And this, my lord, has been sought to be distinguished, ignored by subsequent, my lord, honorable benches of the Honorable Supreme Court comprising of 2 judges. That has been a matter of concern, and hence not only 14.1, but the Honorable Supreme Court in Tejwan's, my lord, order of admission has said interplay between 14.1 and 14.2 and a holistic view on section 14 without delineating 14.1 or 14.2. So touching upon the merits of the case, which hinges upon the right of the parties, which rests on section 14, either 1 or 2. Lord, today, with deepest of respect and, my lord, a greater respect to this judgment, Lord, I would say, my lord, is impermissible in law.
Yes.
Any order which my lord passes today my lord, would possibly, my lord, not be in consonance of the desire of the Honorable Supreme Court. And no party, my lord, can be, my lord, seen to be taking a convenient route which inures benefit, avoiding the diktat, my lord, of the law laid down by the Honorable Supreme Court. Today, the prayer made, my lord, is actually, my lord, an attempt towards that. A convenient route to avoid the implications of Tejwan. I'm not addressing, my lord, on the merits of the case as of now. Okay. I'm not addressing, my lord, on whether the appeal at all has any substantial question of law. If my lord desires to hear the appeal on merits despite Tejwan, which has been cited by before my lord, no, I cannot proceed. Then, my lord, I would say, if my lord is not proceeding, then my lord, would not proceed, my lord, at all, my lord, whether for modification of the order or anything which touches upon the order of admission. Because, yes. Which touches upon the order of admission, because the order of admission, my lord, it categorically frames the questions of law. Okay. And the questions of law hinge on your rights to be determined under Section 14. I wouldn't, my lord, trouble my lord with any more on this, except for the fact that if my lord is desirous of, my lord, passing any order, my lord, on the merits of the case, or, my lord, as prayed for, then, my lord, I need to address, my lord, on the merits of the case.
Very okay.
Submission. Lord, may I only clarify this? Lord, I am not praying for any modification because I'm aware, my Lord, it's a division bench judgment. It's not a modification that I'm praying for. I'm only praying for an independent observation by your Lordship that, my Lord, since what has transpired in the interregnum, my Lord, let there be a protection only on this premise.
You have the protection.
My Lord, in my very respectful submission, that is not, my Lord, a real protection, my Lord, for us.
It is the protection, not
My
to
Lord,
drop the final decree.
that's only not to drop the final decree, but my
Yes.
Lord, the rest of the process will be continuing. My Lord, we have to go and participate therein every day, my Lord. Kindly, my Lord, appreciate our difficulty, my Lord. Every day when the matter is listed, my Lord, in the trial court, my Lord, and I'm instructed it is being proceeded with. So, my Lord, we have to attend.
Okay.
My Lord, if it is not, my Lord, if there is a stay, my Lord, we will be relieved of that process. I'm only praying for this, my Lord. It is not, my Lord, that it will, my Lord, stall up any process any further. Because, my Lord, both are, my Lord, we are before your Lordship.
No, sorry, that cannot be done.
I'm only praying for this, my Lord.
No.
Because otherwise, my Lord, we have to go and participate there every day, my Lord, when the matter is, my Lord, listed.
Very well. Please take down. Hard. During argument of the instant second appeal, the observation of Honorable Supreme Court passed in page 1 within bracket D through LR and others versus Ram Kishan within bracket D through LRS and others. এটা দেখেন এইটা আছে order of the Honorable Supreme Court বলেছে passed in December 9, 2024 is placed. Full stop. Interpretation of section 14 of Hindu Succession Act 1956 is the issue before the Honorable Supreme Court. It has been observed by the Honorable Supreme Court that there are bunches of decision by the Honorable Supreme Court which are contradictory. In the reason thereof, the Honorable Supreme Court has observed in page 1 as follows. A last paragraph in view of that. আচ্ছা, নেক্সট প্যারা করো। In deciding the present second appeal, it appears to me that the property, suit property, alleged to have been transferred, alleged to have been possessed by the wife of erstwhile owner Kalicharan Das, who expired on 24th of November 1935. It has been alleged by the appellant stroke defendant that the wife of Kalicharan Das, দেখো শ্রীমতী ভূতিমণি দাসী, the wife of Kalicharan Das, never possessed the suit property. So the suit property never
Properties, my lord. There are two properties.
two properties. Suit properties never devolved upon the present plaintiff. Full stop. There are some other merits which was argued by the.
This, my lord, I am disputing. Kindly records that this is disputed by the respondents.
There are other merits which was also argued by the learned advocate for the appellant. Full stop. It is the learned counsel for the respondent also dispute the proposition as argued by the learned counsel for the appellant. However, to decide the propositions as argued by the learned counsel for the parties, it appears to me that the applicability of section 14 of Hindu Succession Act and implications thereof is must to determine the instant appeal. Full stop. Without disposal of the civil appeal in Tejvan by the Honorable Supreme Court, the decision by this court is not permissible. Under the above observation, the instant second appeal be stayed till disposal of the appeal, the civil appeal, the disposal of the till a decision be taken by the Honorable Supreme Court in Tejvan. Full stop. Next para. Learned counsel for the appellant argued that it has been during the admission of the instant appeal, an order was passed by the learned division bench of this court, so that the learned court below may proceed with the final decree proceeding, but shall not. But it has further directed that the learned court shall not pass the final decree without leave of this court. Full stop. The learned counsel for the appellant argued that the order for proceeding of the final decree before the learned trial court be stalled till the disposal of the instant appeal. Full stop. Having the learned counsel for the respondent raised strong objection and submits that any order in terms of the prayer of the appellant would automatically touch the merit of the instant appeal, which is not permissible. Full stop. Having heard the learned counsel for the parties, it appears to me that during admission of the instant second appeal, the learned division bench of this court has allowed the learned trial court to proceed with the final decree proceeding. From the submission of the parties, it appears that the proceeding is yet to be concluded and is continuing. Full stop. The division bench of this court has made it specifically clear that final decree shall not be drawn up till the disposal of the instant appeal. I find no justification to interfere with the order passed by the division bench of this court.
Milord, may
Only
I
one
only
thing.
pray for, Milord, there's a
Instead of the word, the appeal be, second appeal be stayed, could it be second appeal be adjourned?
Adjourned.
I'm very grateful. Milord. That's also what I was, Milord, praying for. Milord, with an observation, Milord, if the proceedings in the second appeal be adjourned, Milord, because the difficulty is, Milord, if the second appeal is stayed, then, Milord, essentially, Milord, there will be no second appeal which is pending, which is tearing.
Adjourned.
Adjourned, Milord.
Okay. Very.
And Milord, may it be only recorded one line, Milord, in pursuance of that order of the division bench, Milord, since it has been recorded by your lordship, Milord, may it be clarified that this is protecting the appellants. So no further, only protecting the parties.
It is
Only
already-
this.
No.
But that's not Milord, recorded.
Order requires to be clarified.
It's not clarification, Milord. It's only this recording because, Milord, today,
Order is very specific. Regular order is there, Mr. Bagh.
Milord, the only difficulty is, Milord, we
What
do not know
difficulty
when
you are
this matter will come
I
back.
cannot understand what you are facing. What difficulty you are
Milord,
facing.
the difficulty which I'm under instructions because, Milord, I'm not there in the trial court
Yes, I
proceedings,
understand.
is, Milord, that every time, Milord, this is being listed, Milord, they have to go and participate. So, Milord, that is, if,
That is
Milord,
the
today,
desire of
if
the
this is,
bench.
Milord, today, if that was, Milord, because the Honorable Division Bench never, Milord, could foresee that this order in Tejpan will come, which, Milord, I do not know when the larger bench will be, Milord, constituted. Maybe 6 years, maybe 5 years, Milord, when we come back.
The difficulty is that
Milord, it will
whatever may be
continue
the
forever.
proceeding, whatever may be the proceeding,
Lordship.
ultimate is the final decree.
Indeed, Milord. But in the meantime, Milord, every time when the proceeding is, Milord, happening, Milord, they have to
Let
go
it
and
be
participate.
concluded. Let it be concluded to the ultimate.
That is
And
because they are not
That is the only
permitting.
difficulty. Milord,
That
today
is
it's not
because
that
they are
it is not that we are not permitting. I took
permitted.
that instruction, Milord. My instruction is that there is no impediment from our end.
Well,
I
then
do
I
not
need
know.
to show the orders. I
Yes,
need to show
yes,
the
that may be,
certified
but
copy
that is my instruction. That it is not us. I can show from the order, Milord, which my learned senior friend is indicating because I've taken
that
specific
is
instruction. It is
altogether
not
separate
us.
issue has to be determined in the appeal.
Yes.
The only difficulty, Milord, the reason I'm making this prayer is, Milord, in other matters we have seen when there's a reference to a larger bench in the Supreme Court, it takes, Milord, 5 years, 6 years to only form the, Milord, larger bench. And then the decision happens, Milord, years later. But I am only concerned if, Milord, this process goes on. That is the only reason, Milord, I made that prayer because, Milord, the Honorable Division Bench could not have foreseen that, Milord, this situation will arise. Has now that the situation has arisen, but one clarification from your lordship only to this extent, which will not harm, Milord, either of the parties.
It would.
I do not understand, Milord. Then there is something wrong, Milord. Then there is something wrong. Only this one observation is what I was praying for.
No. Okay.
Very well,
Thank
Milord. I leave it to your lordship.
Okay.
I'm very deeply obliged, Milord, and I apologize, Milord. We have wasted a lot of time of your lordship. We were under the impression that this will be heard, and Milord, this order, Milord, came as a surprise. I understand that, Milord.
Disposed of in this month.
It came as a surprise, Milord. So we could not.
Very
deeply obliged, Milord. Very deeply obliged. Yes.
কালকে রাত্রে যেটা নোট করলাম সেটা কোথায় ভাই? আরেকটা দুটো খাতা দাও। এই খাতা আছে? এটা না, ওইটা দেখো। এই যে এইটা? না, আরেকটা আছে ওইটার নোট। ওইটা
ওই ইয়েটাতে আছি যেটা অরিজিনাল ঘরে করলাম ইয়েস on the last occasions my lord
So we are in delay in building up stocks.
in building stock my lord now my lord I myself exercised on that because there are many papers my lord so I take you my lord to a proper my lord. I invite your lordship's attentions my lord at page 163 my lord 153 my lord yes my lord first my lord said take your lordship to page 160
You refer me 160, then 162,
yes
and thereafter
then
163.
163
Yes.
then 163 my lord I invite your lordship's attentions my lord top of the table my lord
Yes.
that Puja Festive 2018 cut-off date 14th October 2018
Yes.
your lordship will find my lord on fourth column my lord that the allotted quantity in quintals at the bottom 1,85,000 18,533.14 metric ton
For Purbo Bardhaman.
for Purbo Bardhaman.
Yes.
That was the allotted quantity.
Allotted quantity in quintal.
Allotted quantity, my lord. And the authority, my lord, worked out, my lord, that there was a delay in stock build up for 16 days.
It has to be built up within 14th of October.
Within 14th of October.
And you have allegedly built up on 31st of October.
Yes, my lord. Then I'll take it. This is absolutely contrary to records. At page 187, my lord, put up for history. At page 187. This is the stock register. Stock report for 1st October 2018 to 31st October 2018 at page 187.
October.
14th October at page 187.
Page 187.
Yeah, 87. Your lordship will find from date 14th October.
Yes.
There was a stock.
Opening stock
21,683. Closing stock 21,683.
Total stock. Closing stock.
Closing stock. So, but my lord, they my lord recorded in their my lord calculation sheet, my lord, so put it in the table that 18,533.
এটা কিন্তু certified
So there was, and this is certified by their own depot manager.
No, it is in respect of which go down?
In respect of go down Anjali Bagan, that is Purbo Bardhaman.
It is Purbo Bardhaman?
Yes, it is Purbo Bardhaman.
And even inside এই যে এখানে এন্ডোর্সমেন্টটাতে দেখুন there is a slight
even it would appear
Part of
not
it
from
is
the endorsement that is Purbo Bardhaman. Purbo is not very visible.
but
That is Purbo Bardhaman WBSCS Limited. But Bardhaman is visible.
Stock register.
Yes, visible, but
okay.
Then, my lord, I'll take your lordship, my lord, to page 169. Because there are, my lord, for 200, 500, this we are not, my lord, giving trouble, my lord. Only, my lord, at the major rate, which I have worked out, 7,83,286 out of 8 lakhs. So, then page 169.
169.
169.
Yes.
Yes. Cut-off date 29 January 2029. Second table. First table, there was no delay. Second table. Cut-off date 29 January 2019.
Yes.
Go down Dankuni Hubli. Allotted quantity 3,818. Stock build-up date recorded as 21st March 2019. This is again without contrary to material records. I will take your lordship.
You are required to be built up on 29th of January.
Yes, my lord.
They have alleged that you have built up the stock on 21st of March.
March 2019. I take your lordship to page 177.
Delay of 50 days.
Yes.
Calculated.
Yes, my lord. Then 177 page.
One
177. Fresh stock build up at Radu and company go down Dankuni. 28 January 2019. Old stock transfer from BD Casting Radu and company Dankuni. 460 quintals. Fresh stock build up as on 28 March 2029. 7,500 quintals.
28 January.
28 January. So there was 7,960 as on 28 January 2019 in Dankuni Goda. Whereas it was recorded as 3,818.39 and alleged build-up stock was shown as 21st March 2019.
You have already built up on 28
January 2019. Then, my lord, last table. Cut-off date 29 January 2019 in respect of Kharagpur, Paschim Midnapur.
Yes.
Allotted quantity 1,655.62. Stock build-up date, cut-off date 29 January. Stock build-up date, it was shown as 14th February 2019. This is also contrary to reports. I'll take your lordship to page 202. Yes. Daily stock report 2002 page. Daily stock report of sugar for the month of January 2019. $200.
Yes.
Yes. So last column, closing stock for the month of January 2019. Right hand side, last column.
Name of the point, Chorongi, Kharagpur.
Yes, Kharagpur. Go down. Closing stock. Right hand side, last column on 29, 30, 31st, then 29.
Yes.
1,680.34. So stock was built up, Milord, on 14 January 2019.
14 January
Not Milord on 14 February 2019.
14 January.
As they have held.
16.34 starts from 14 January.
So month of January 2019, you were saying?
Yes.
Daily stock report of sugar for the month of January 2019.
Yes, Milord. Last column, 29th January, 1,680.34.
34. This is the date is otherwise left side date is
of that date, Milord, is a
2018.
It is 19. So one, Milord, it has been corrected one only. In my copy, it is 19.
And in fact,
otherwise, Milord,
even district
daily stock report of sugar for the month of January
2019.
Allotment of December 18 and January allotment of January 19.
bottom right. And also এইখানেতে এই এন্ডোর্সমেন্টটা এখানেতে দেখা যাচ্ছে না, এটাতে এই কাগজটাতে দেখা যাচ্ছে। কারণ আমি যশোর এই কপিটা কি দেখাবেন, এই সেটটা কি দেখাবেন? এই যে এখানে
And
তো
from the other documents, my lord, that
Yes.
that I will take your lordship to the other documents also, my lord. So from those documents, it will be apparent that their endorsement was there. my lord.
Yes.
Yes. Then, my lord,
কোথায় গেল আমার ওই লেখাটা বলো যে কি তোমার
ওই যেখানে আমি নোট করেছিলাম,
আপনি তো বার করে দিচ্ছেন।
বার করে then, my lord,
এইটা কি?
yes, yes, yes. Then, my lord, I take your lordship at page 171. Go down Dalpuri Hooghly.
Yes.
Allotted quantity 3,880. Stock build up quantity, it was shown as 7,600.
7,600.
600. Then, my lord,
15 days delay, they say.
15 days. Then again, I'll take your lordship to page at page 177.
Dankuni.
Dankuni. That is 7,960. Because, my lord, it would be apparent from two documents. That is at page 169 and 177, 171. I'll take your lordship to page 169 also. Because otherwise there might be a confusion.
Yes.
At page 69, Dankuni Hooghly,
second table.
allotted quantity for
second
the allotted quantity,
second table
second table.
Allotted quantity
Quantity within the cutoff date of 29 January 2019,
yes.
3,818.39.
Yes.
And in the same go down at page 171,
Allotted quantity
3,818.
139.
Yes, my lord. So, my lord, the total quantity was, my lord, 7,636.
7,000.
Allotted quantity 6,736.78.
Yes.
Then, my lord, your lordships will get it at page 177. Total quantity
7,900.
960.
Covering that.
So, my lord, covering those periods. So, during that period, entire stock was built up. And for your lordship, quick appreciations, my lord. My lord, এটা দাও,
সেলাই করা আছে।
দাঁড়াও, এটা
এখানেতে ইন্ডিকেশন
reply.
রিপ্লাই কখন
Reply করো। For your lordship, quick appreciations, my lord.
আমরা পেজ 118 তে এই পেজ 15 তে যেটা
A
বলেছি
table
ওটা
has
দেখিয়েছি।
been prepared, my lord, so that there may not be confusion.
এখানে বলা আছে
And the document has been, my lord, made grave reference at page 15, my lord,
LL
of the affidavit in reply. Paragraph
LL
Affidavit in reply.
Yes.
15 টা কত এর আগে আছে
5 LS at page 15 of the affidavit in reply.
Page 15.
Page 15.
Yes.
It is further stated that the penalty which was levied upon the petitioner on account of delay in the built-up stock at various places, including Dankuni, Bardhaman, Murshidabad, and Kharagpur, was done without taking into consideration that there were sufficient stocks at all times to the respective places. A detailed chart of penalty impositions for purported delay in build-up of stocks imposed by the respondent authorities, indicating the actual stock position, which show sufficient availability of sugar stock in the respective godowns, along with details of supporting documentary proofs, is annexed hereto and marked with the letter C. I crave leave to refer to the copies of such supporting documentary proof at the time of hearing, if necessary. So, my lord, producing these documents, my lord, এক কপি ওনাকে দিয়ে দাও আমার সাইড। That
we same table
I will take your lordship at page 118.
And the type copy
118 and 118A is a type copy.
A and B.
A and B.
And the same table is replicated here.
And the same table has been replicated, my lord, which I have already handed over to your lordship.
Supporting documents.
With the supporting documents.
Yes.
Purva Bardhaman, penalty amount per metric ton 1,56,134. Allotted quantity 18,533. Work order period, last date for building up stock, cut-off date 14th October 2018.
এইটা আপনার কপি
Delay in stock build up 16 days.
They allege.
Yes, my
এইটা
lord.
আপনার কপি
That, my lord, that your lordships get it at page annexure A, my lord, that what I have already shown, my lord, at page 187 of W.
Yes.
It is indicated.
Yes. Then, my lord, second, Purva Bardhaman.
বেশি দেখিয়েছিল টোটালটা রিমার্কস
Penalty amount per metric ton 500 metric ton 17,506. Last date for building up stock 1st October 2018. There was a delay of 2 days.
Yes.
Penal quantity 3,501.
তো এটা আপনার কপি সুবিধা হবে আপনার
Stock build up. So
এখানে তো ওই অ্যালটেড কোনটা বেশি দেখানো ছিল এটা আমাদের ওই মিনিটস অফ দ্য মিটিং এর মধ্যে কপিটা আছে ওখানে বলা আছে
then,
এই
my
যে
lord, in
এই যে
support of
কাগজটা
that, I
আপনার
referred, my lord, a
এই যে
document which has already been disclosed in the affidavit and reply, my lord.
opposition
Your opposition
of their opposition
of their opposition at page 32. ওদের oppositionটা বার করে page 32. That it was mentioned on the top of the document. Page 32 of AO.
Page 32 they.
Okay, Milan. Page 32. Now. Yes. Your lordship will get it at page 30.
Minutes of meeting.
Yes, yes.
এই যে এই কথাটা
That's correct. It was also decided in the meeting with respect to godown at Bardwan that another godown at Bardwan is to be arranged by the supplier as the previous proposed godown capacity is insufficient for storage of allotted quantity of 7,361.49 quintals. In this regard, it was also decided that for the time being, sampling for quality control will be collected of 5,932.5 quintal of sugar stored at proposed godown at Bardwan.
এটাই দেখাবার ভার্সেস ওদের টেবিলে ওরা এটাকে 10,000 কত বলেছে এইটাই রিমার্কসটা
Yes. So, my lord, the allotted quantity was 7,361 as it was decided in the meeting.
signed by the managing director of the
And it was signed by the managing director at page 33.
Yes.
33.
Then I'll take your lordship, my lord.
That's 10,000.
Yes.
Whereas it was 7,000.
To the document at page 1 of the compilation. 1st October, closing stock 7,361.
Yes.
So on 1st October, we had 7.
So, Milord, allotted quantity, Milord, there was sufficient stock, there was the allotted quantity, Milord, was built up, Milord, was available, Milord, at the go down. That is 7,361.
But in they have shown it to be higher. ওরা ওই 10,000 দেখিয়েছে।
But in their table, they recorded as 10,000 something.
ওই যেটা 100 যেটা আপনার ওই রিটের মধ্যে যেটা আছে।
At page 164. What?
Page 164.
164.
Yes.
It was shown as 10,862 at the bottom. Allotted quantity. Fifth column.
10,862 for Purbo Bardhaman.
For Burdhaman. Though, Milord, it was decided that the quantity should be allotted 7,361.49 quintals. And the same quantity was built up. That is not much amount. There was a delay of only 2 days, Milord. So I will not take your troubles, Milord. I will not give you trouble, Milord, your lordship, Milord. So I take your lordship to serial number 7. Dankuni Hubli.
Yes.
Penalty amount 4,74,343.
Yes.
Allotted quantity 3,880.
দেখালাম 7,960 আর এখানে একটা কথা বলে দেবেন ও পেনাল্টি ডিডাক্টেড করেছে প্রচুর বেশি 500 টাকা পার টনে হতে পারে ওখানে মাত্র বলা
G. Annexure G. Annexure G at page 8
of the compilation.
Of the compilation. $7,960 in 2 tranche, Milord. The quantity was allotted 3,818.
Old stock was 460 and fresh stock
7,500. The total 7,960.
This is in case of Dankuni.
It is in case of Dankuni.
You have already shown it, page 177.
So that is why this is the compilations.
Yes.
We prepared a table, Milord, so that your lordships at a glance, Milord, will appreciate the whole stock picture of So that's why, my lord, we have to. So therefore, my lord, in this writ petitions, my lord, the writ petition, my lord, challenge was thrown on two grounds. My lord. One, failure of quality controls, my lord, and the penalty was imposed to the tune of rupees 2 crores 82 lakhs.
Yes.
And another, my lord, and the second ground, my lords, of failure in building up stock, my lord. That is 8 lakhs 12,000. So this is the, my lord, against, my lord, such purported actions, plus the instant petitions was filed, my lord. Initially, my learned friend raised, my lord, objections as regard to the maintainability of the writ petitions, my lord. So therefore, I argued, my lords, on that point, cited, my lord, 5 judgments, my lords, including the judgment, my lords, whereupon the Supreme Court came to a findings, even if despite subsistence of the arbitrations, my lord, that the writ court is not patroned in entertaining writ petition. And in all other cases, my lord, because arbitrations is a contract within contract, my lord, but in all other cases, my lord, the Supreme Court has held, my lord, the writ is maintainable in the field of contract, at least on three specified circumstances, that is that which has been called out in Whirlpool's case and followed by all other judgments. So that's I have cited in your lordship. And the second ground was that, my lord, that the impositions of penalty, my lord, that impositions of penalty, my lord, that, my lord, that was, my lord, challenged on 3 grounds. One, malafide, because so cause was issued, my lords, without giving any opportunity of hearing, without giving any reasonable time, my lord, to give reply. Even less than 24 hours times, that was this penalty was imposed, my lord. So anything, my lord, which is done in a hot haste, Supreme Court has held that it should be presumed to be valid. So I cited 2 judgments on that point. And the second, my lords, is the utter non-application mind. It is also one of the facets of Article 14 of the Constitution. Because requirements of Article 14 is duty to act fairly, justly, bona fide, and with a sense of responsibility. That's the requirement. So every actions must be structured, my lord, within that parameter. So, my lord, in this case, my lord, so what happened, my lord, that the prescribed parameters, my lord, S30 sugar, my lord, should be supplied, my lord, or higher variety. I supplied S31. This is higher variety. But still, I was saddled with a show cause notice.
Yes.
This is a glaring instance of non-applications of their. That is, my lord, the second limb of my challenge. And the third, my lord, that the, my lord, that, my lord, my lord, terms and conditions of the tender document specifically stated, my lord, that the moistures, my lord, that the moistures content shall be 0.1, my lord, 0.0.
0.10.
0.10, 0.10, and that should be, my lord, in conformity to the standard laid down by the Food Standard Security Act.
Yes.
So, Food Standard Security Act provides 0.50. So, if, my lord, the requirement, if it is, my lord, under the statute, my lord, and if it is otherwise put in the contract, my lord, then statute shall override the contract, always. So, therefore, on their testing, my lord, when the after supplying of the sugar, it is their contentions that upon inspections and testing, it was by their own laboratory. It was found that there was, to some extent, a percentage of moisture. That is within, my lord, that is within 0.5. That is first. Secondly, it was again retested on our request, and retesting was done, and it was found that this is well within the parameter. So less than 0.01 or within 0.0. So all the quantity of sugar was supplied to the end user, the consumers,
yes,
and that was consumed. There was no loss of the corporations. And the third, my lord, that the testing, my lord, which was done, my lord, by not the methodology which was applied, my lord, not, my lord, my lord, in conformity to the, my lord, standard prescribed, my lords, under the Food Standard Security Act. So therefore, my lord, the petitioners, my lord, filed an application on the Right to Information Act, short for information, and they clearly, my lord, they admittedly, my lord, if it was, they admitted, my lord, that their laboratory is not duly calibrated, my lord, and it is not as per standard of the FSSI, and that was maintained by their own standard. This is absolutely contrary to the provisions of the contract.
And the
Under the contract that has, and the rules is also provides that how the testing is to be done, and from which laboratory, and who will be the laboratory banned by the persons having the requisite qualifications. All has come out by way of Right to Information Act. No a requirement was filled up complied with. So therefore, that was our third attack of this impositions of penalty. And so these are the as regard to the quality failure is concerned.
Yes.
qualification ছিল না
The qualification testing. And then failure in building up stock that I have have already taken you to from the various documents, and from those documents it was apparent that at the relevant point of time there was the sufficient stock as per the quantity allocated.
এই কথাটা একটা জায়গাতে ইভেন একটা এক্সাম্পল আছে যেখানে তুমি 500 টাকা পার টন করতে পারে, সেখানে তো ওরা এত টাকা দিয়েছিল পেনাল্টি। দ্যাট ইজ অলসো ইলিগাল, নট রিকোয়ার্ড এনিওয়ে, ইট ইজ নট।
Yes. So on this count, this penalty, which was imposed, by issuing a several, order of impositions of penalty that are liable to be quashed, as well as, the penalty imposed upon the failure of stock buildup.
So impugned decision is at?
Yes. It's at 8. Yes. What? Yes. At 126 to 131. 130. Or 130 or 130.
আমাদের প্লেয়ারটা আছে 50 করে দেখুন, আমরা সব ওয়াশিং চেয়েছি। প্লেয়ারটা আছে 15 করে অন।
And
players are
all those order of penalty was
প্লেয়ার দেখুন 50 করে অনওয়ার্ড আছে, প্লেয়ারে সব বলা হয়। ম্যাডামাস একটা করে ম্যাডামাস চেয়েছে
126 to 130.
130 and in the instant petitions
এখান থেকে
the petitioners paid for each of mandamus for quashing of all the order of penalty at page 54 onwards.
প্লেয়ার্স সবকটাকে ধরে ধরে চেয়েছে এবং তারপরে টোটাল পেনাল্টিটাও একটা জায়গায় বলা আছে পরের দিকে প্লেয়ারে।
That is each of in the nature of mandamus setting aside and quashing the improved notice of penalty bearing number so and so dated so and so number 2.
সবকটা বলা দরকার।
All of order of penalty
আর এই জায়গাটা এই জায়গাটা এইখানে
and I invite your lordship's attention
the
to
sum of
prayer each of the petitions
at
page 57. Petitioners paid for a heap of mandamus
because they have already deducted this sum.
Because it has already been deducted from the running bill of the petitioners. So therefore asking for refund of the amount 2 crores 39 lakhs 85,800.
পরে কথাই জানি and
the award of damage
Prayer H.
Yes.
H and also এখানেতে আপনার এইটা আছে, আমার ড্যামেজ চেঞ্জ আছে এইখানে এই যে এইটা তো এইটা না আপনার দিলে
delay in approval go down to
এটা
These are all been not prayed for our damage, we don't. So
Right.
we are not praying for all this, we don't.
Okay,
Only for
okay.
we are praying for.
Okay.
Right.
Advocate General, kindly fix the date for reply argument and.
When? Tell me.
If this matter.
Next week.
Next week, 30th January at 3 p.m. if possible. Subject to convenient.
কত কত
30 তারিখে 3টের সময় বলছি। 3টের সময়। সেকেন্ড হবে 3টের সময়। কি করে একটা কিশোরদার আমার সাথে ফিক্স আছে
30th January the Thursday. I have determination of original site.
Friday.
Friday is the second appeal. 29th.
29th. Then also kindly keep it at 2 p.m. if
Yes, 29th 2 p.m.
it will be fixed for the time being.
Argument on behalf of the petitioner concludes. Let the matter appear in the list on 29th of January 2025 at 2 p.m. as a pattern matter.
Yes, update to you.
David.
টোয়েন্টি-নাইন দুটোর সময় জানি কি শুরু হয়ে গেল পাওয়া যায় না আমরা যখন
এটাই তো মুশকিল ঠিক হওয়ার
ঠিক আছে,
সময়
এই ডেটগুলো পর
আমার সুতরাং সুকুমার ছিল সব বলেছে
আমি আমাকে বললে চলবে কিনা
I'm a petitioner, madam. বুঝতে আছে সব দাঁড়া
Yes.
मतलब one my lord
Item number 12.
12 my lord.
This is second call.
My lord. Every service. मतलब one my lord को भमत दत्त was the original my lord के MR dealer. In the year 1993, he died.
In the year 93.
93. Well, he has no bachelor on the Dejin melody. He take the adoption. At the time of the death, he leaving behind the one adopted son. The adopted sons made an applications for MR dealership. On the basis of the applications, the authority concerns scrutinized and issue the appointment 1994. And thereafter, my lord, successfully, my lord, MR dealerships continue. In the month of October 2024, after 30 years, my lord, respondent authorities issued a notice. The contents of the notice, the ones 2010, 14 years back, Laner Civil Judge Senior Division, the first a opinion was given. The petitioner is not the rightly adopted son. He cannot pass the property, transfer the property. That the dispute the property. The petitioner totally dark my lord, who is petition, what is, and on that date, petitioners made an application before this authority concern. In this notice, even my lord, know the suit number, only order date kindly my lord, notice my lord, running page 23. It transpired from the order dated 6th October 10, passed by Lanet Civil Judge Senior Division Additional Court Bakura, has passed the judgment In the circumstances, I am of the opinion that the alleged adoption was not made according to law, and Kashinath was not adopted son of Bhamad Datta, and he cannot inherit the share of Bhamad Datta in respect of suit property, and he has no right to transfer the share of Bhamad Datta to the plaintiff. Regarding the property, there is no MR dealership. Now there is no suit number, nothing, no appeal number, nothing. No papers was supplied. Next page, I have made a representation. Only pray for time. And rush to this learned code below, which order, what is the everything. Kindly, my lord, next page 24. On receipt of your office memo number so and so, supply, and adoption Kashipur and abstract abstain to know that a civil case was disposed of on 6th October 2010 by the Learned Civil Judge Senior Division, Additional Court Bankura, which was completely not known to me, and no notice were even sharp upon me, and had been a fact that the case was pending before a competent civil court Bankura. I could have appeared and contest the suit. It is most humble beg to draw to your kind attention that the aforesaid order dated 6th October 2010 passed by the Learned Civil Judge Senior Division, Additional Court Bankura, has been passed behind my back and knowledge. However, on receipt on your aforesaid memo, I came to learn the alleged order dated 6th 10 2010 passed by the Learned Civil Judge Senior Division at Bankura behind the back and knowledge of me, and accordingly I had immediately applied for the certified copy of the said order 6th October 10. An advocate at Bankura Court, he said certified copy of the order dated 6th October 10 has not been supplied to me as yet, and I am waiting for same. In such a situation, it has came very much difficult for me to submit any explanation regarding the matter as required in your memo mentioned above, and for the at least 3 months time is required to submit my explanation required by your office. I therefore earnestly request your highness to be kind and sympathetic enough and allow at least 3 months time to submit my actual explanation as required by your office. And then, my lord, again, my lord, without considering again the notice. My lord, only my lord, kindly, my lord, 20, my lord, 25 page, my lord, next page, my lord. In reply to the explanation, notice bearing number stated under referred, your reply dated 13 November 2024 is not at all satisfied. As such, you are hereby direct to appear before the office of the undersigned 29 November 2024 Friday at 11:10 a.m. for personal hearing along with all relevant papers and documents. This is the my lord facts, my lord.
So whether you have appeared?
My lord, I have appeared and asked the my lord copy, my lord, they nothing supplied. I have appeared, my lord. I have to go each and every my lord, I have
What you want now?
My lord, kindly, my lord, keep the time, my lord, all the hot order, my lord, the basis, my lord, supply my document, my lord, department, in the hand of the department, on what basis, my lord, complaint, my lord. Direct the department on which basis proceeding is initiated, my lord, document must be supplied. Without annex any document, my lord, petitioner how to know, my lord.
So why you appear before this court?
My lord, it court, my lord, this is the my lord, apprehending, my lord, on the basis of the hearing, if the terminate, my lord, very, my lord, the court
Sir, any termination order is there?
No, my lord, if the
Then you,
my
then
no,
you receive the order, then come.
no, my lord, if the courtship stay will be taken, my lord, I'll, my lord, give the I'll out of job, my lord.
No, you have challenged the notice.
Yes, my lord, I have challenged the notice, my lord.
Dated 27/11/2024.
My lord, two notice I have challenged, my lord, 29 October 2024 and my lord, 27/11/2021.
Hearing notice, you have participated the hearing.
No, my lord, I have with objection, I have, my lord, this is first, my lord, notice, I have the objection. And second, my lord, with objection, my lord, without, my lord, objection, with the ex party, what will be passed? But at least, my lord, reasonable opportunity, my lord, on what basis proceeding was initiated. But all the document must be supplied.
So give me something. What is the order against you?
No, I do not know.
Then you receive the order, file the representation with the authority, and come.
My lord, yes, my lord, I have filed the representation, kind of 24. This representation must be considered. The supply the order on whose basis this proceeding was initiated. Whether I'm the party to the proceedings or not.
You have applied for the certified copy before the civil court.
Civil court, my lord, they are not trace out, my lord, the TS number, my lord, there is no number supplied, my lord, if the, my lord, 14 years back, my lord, if the number, my lord,
Let them take a decision and you come. Otherwise, you have to file a representation with the authority.
But I have the represent, my lord, direct the authorities to supply all the papers on whose basis proceeding was initiated.
No.
But without supply the document, but
they have not taken any decision. So
no,
what order you want now?
No, my lord, I am not. I am that, my lord, the proceedings, my lord. Proceedings is the bad, my lord. In the prima facie proceeding is bad, my lord. If the, my lord, disclose anything, my lord, if the anything is disclosed, my lord, how is the, my lord, explanation given, my lord? But this is kindly, my lord, the nature of the notice, 29 October.
Okay, hard.
My lord, ultimately, my lord, state government will produce, my lord, affidavit, only, my lord, report in the form of affidavit. My lord's perusal only. The on what basis, my lord, proceeding was initiated. Directly the state government, my lord, file this, my lord, short, my lord, affidavit.
You made a representation with the authority and come. Press representation.
Well, I have the, my lord, 24, my lord, page.
No. This is not the representation. You have attended the hearing.
My lord.
You have attended the hearing.
No, my lord. My lord.
You are running the license now?
Yes, my lord. Running.
Run the license. What is the issue?
No, the issue is, my lord, but the proceeding, my lord,
what is the proceeding? What is the order? Nothing is there.
No. If, my lord, one proceeding was initiated. Right, Lord, my lord, if that not disclose me everything, I will, my lord, cannot, my lord, unable to reply. My lord, 29, my lord, at least TS number who should or appeal, my lord, only TS number will be, my lord, Lanet court below, my lord, 23 page. Only order.
Okay. Please take down. Petitioner challenge the notice. Challenge notices that any notices issued by the Subdivisional Controller Food and Supply Raghunathpur Purulia, dated 29/10/2024, whereby the concerned authority asked for the explanation of the petitioner regarding an order of a civil judge, senior division, additional court, Bakuda, against the present petitioner. So it appears that the impugned notice did not mention the number of the title suit as well as the name of the court. Full stop. However, the Hearing was conducted by the concerned authority, and the petitioner has appeared on the hearing. Having heard the learned counsel for the petitioner, the state respondent is directed to have you served.
Yes, my lord, I have every service, my lord.
তার প্রথম লিখবে despite service none appears on behalf of the state respondent. কি বললাম তার প্রাটিক ফার্স্ট কি বললাম having heard the learned counsel directed to file an affidavit. File an affidavit in opposition. File an affidavit in opposition within 8 weeks, within 4 weeks from date. Reply if any by the petitioner within 2 weeks thereafter. Let the matter appear in the list. Let the matter appear in the monthly list of March 2020. Affidavit of service filed on behalf of the petitioner is taken out. Next.
The petitioner heard this matter yesterday and directed my line to take instruction.
This is Adam Court State, led by Mr. Rajat Dotto. He is engaged.
I had a talk.
Number
Let
25.
I start, it will take some time. The petitioner's father was a fair price shop dealer. Page 20 is the license.
Yes.
This is kindly see my lord, license, page 20, in favor of Ekhlaq Hussain Ansari. That is the father of the petitioner.
Yes.
My father died on 16th November 2014, which will appear from page 22.
Yes.
Page 22, 16th November. Then I applied for, and ultimately license has been granted to me on 14th December 2021 at page 23, bottom left-hand side. After 7 years.
Yes.
But this 7 year is also to some extent some relevancy. After 7 years, I got the license. Then license has been renewed, page 24. Kindly come to page 25 up to 31st December 2026. Last line of paragraph 13, the license shall be valid up to 31st December
Yes.
2026. Then what happened, my lord? Your lordship, kindly come to para 8, page 4 of my writ petition. Onward, two, three paragraph I have to read, my lord. At page 4.
Humble submission before lordships. Kindly praying for not to take a mistake. My senior is engaged, code number 25. Very serious matter.
Every day you would be appear before the senior, before the senior benches,
as per your lordships,
and not before this court.
As per your lordships, and the apology, because distraction not.
Conclude my submission, whether he has come or not, kindly.
You take note of.
My lord, paragraph 8, if you also kindly read. Your petitioner states that after granting the said fair price shop license in favor of your petitioner, subsequent thereto, your petitioner has been provided with ID number for operation of the EPOS machine, being ID number so and so in first quarter of January 2022. Your petitioner states that although a fair price shop license had been granted in favor of your petitioner on 14th December 2021, however, allotment of ration articles had been delivered to your petitioner by the concerned distributor firstly on 30th December 2021 for the distribution month 2022, January 2022, and thereafter your petitioner had started distribution of ration articles to the tagged ration card holders from the month of January 2022 through EPOS machine number so and so. Your petitioner states that from the very beginning, ration article has been allotted to your petitioner much lesser than the requirement as per tagged ration card. Accordingly, minus balance stocks of ration articles were being shown in the EPOS machine. Your petitioner states that since your petitioner was unable to deliver ration articles to all the tagged ration card holders of your petitioner due to shortage of delivery of ration articles, on number of occasions your petitioner verbally intimated such facts to the subdivisional controller, FNS Purulia Shodor. However, such verbal representation yielded in no result. Your petitioner states that although on 28th August 2024, your petitioner had been called for by the subdivisional controller Purulia in his chamber at 2:30 p.m. Your petitioner states that your petitioner on the very same day on so and so, your petitioner was present at the scheduled date, time, and venue as per direction of the subdivisional controller Purulia. Your petitioner states that on the very same day, that is on so and so, The subdivisional controller Purulia handed over your petitioner a printed document wherein actual stocks of ration articles as had been displayed in the EPOS machine has been recorded. Your petitioner further states that in the said printed document, excess quantum of ration articles in the account of Hirade, with whom ration card of deceased father of your petitioner was temporarily tagged has been disclosed within second column. It also says that in third column of the said printed document under the caption new balance of Ajahuddin Ansari, that is the petitioner before lordship, after merging 1 quintal has been disclosed by adding the entire excess quantum of stocks of ration articles in the name of Hirade with my actual stocks, and subdivisional controller put pressure upon your petitioner for endorsing the signature of your petitioner in the said printed document. And due to such pressure upon your petitioner, the subdivisional controller took the signature of your petitioner forcefully in the printed document, which was against willingness of your petitioner and under threat of suspension and termination of the dealership license. Paragraph 15. Your petitioner states that such wrong entry of ration articles as disclosed in the printed document, where the signature of the petitioner has been obtained, forcefully has been displayed in the EPOS machine. Your petitioner states that your petitioner intimated such authorized entries of stocks of ration articles in the EPOS machine of your petitioner to the subdivisional controller Food and Supply Sordor, but neither any steps has been taken nor by the divisional so-and-so. Then if you have to kindly turn to paragraph 18. Your petitioner states that after such representation as so-and-so, when your petitioner was waiting with an expectation that the respondent authorities would adjust the stocks of quantum of ration articles, all on a sudden, in the allotment order of month of September 2024 for disbursement distribution month November 2024, and in the allotment order of month of November 2024 for the distribution month December 2024, from such huge excess on shown quantity of stocks of ration articles, a considerable portion of stocks of ration articles has wrongfully been adjusted by way of delivering lesser quantity of quantum of ration articles than the required quantum of minimum allotted quota of ration articles. It is pertinent to mention here in that more or less 20% quantum of ration articles have been deducted from the required quantum of monthly allowance. So paragraph 19, your petitioner states that in the month of December 2024, your petitioner came to learn that for distribution month January 2025, from such huge excess shown quantity of stocks of ration articles, a considerable portion of stocks of ration articles have wrongfully been adjusted by way of showing lesser quantity quantum of ration articles. It is also pertinent to mention that more or less 20% quantum of ration articles have been deducted. Now you will also kindly come to page 26. Well, this is the document. Kindly see what they have done. Government of West Bengal prepared food and sub 28th August. Item number given balance Ajahuddin Ansari, that is my client, in quintal minus 7.116. Have you also got minus? Then balance Hirade, with whom the cards of my deceased father have been tagged. 7 years after this license has been granted to me. So and so, then new balance of Ajahuddin Ansari, kindly say positive. 11800 minus 7.116, 4.685. That was a minus stock. Now it has become 4.678. Then huge quantum, kindly see my lord. PHH ATA 128,662 minus 172 from the other dealers quota, adjusted 44. Now next page, my lord. I made a detailed representation saying everything. Minus balance, everything I have stated. Addressing to the director, district controller, subdivisional controller, all. In addition to my previous representations. Now what happened, my lord? Kindly turn to page 31. This is the allotment order. Kindly see, my lord, last 3 columns of the top of the table. CB, deduction from excess balance. Have you also got? Page 31, top table, right hand side, 3rd column from right hand side. Deduction from excess balance in kgs.
Yes.
Total adjustment CB for the month in kg. Net allocation for the month of so and so. It will be clear, my lord. These all items have been given. Kindly come to the next page, page 32. 32 also says, my lord, adjustment. Minus balance has now become a plus balance, and from this plus balance they are adjusting. My father died 2014. I got the license 2021. According to them, father's account are being bought into. It has been given to Hirate. Now from Hirade to me. Let them file an affidavit, my lord. At least one matter must be disposed of. January already deducted. January already deducted also. Your lordship cannot understand anything from these documents. No intimation, no order, nothing. My representation is still pending for consideration.
Yes. Yes, my lord. My learned senior friend has submitted the case of the petitioner only. But the fact is that the unutilized stock, which were associated with the previous ID, that is his father's, that has not been returned. That has not been returned. That has to be realized from the present ID. So therefore, by virtue of the order scheme for correction, the deduction has been made. It's being made now on and from November. But my lord, the petitioner, this is not a new fresh vacancy, my lord. It's a resultant vacancy on compassionate ground in place of his father. After his father died in 2014, but all the ration cards were tagged into the nearby, but ultimately the petitioner was in action, my lord. He was running the FPS and all. Now the government, in terms of correction order, which has been issued on 12th of February 2024, correction is being made because the unutilized stock which were associated with the previous ID has to be merged with the present ID.
How? One Hirade was tagged. Why no explanation is there from Hirade?
That's why. Well, there is a
How the decision has been taken like that? If you serve 20% less quantity, the beneficiary will get 20% less.
So, my lord, can you see?
How that can be adjusted?
Page 26, my lord, as has been led by my senior friend, my lord.
Yes.
This is the first column. This is the balance of Adaluddin Ansari, the petitioner.
Minus balance.
Minus. Why? Because the second column is the balance of Hirade account 1 lakh Ansari, which is the father of the petitioner. License number of
So the unutilized balance
Yes.
of his father, of the father of the petitioner, and also the Hirade
No,
was upon the present petitioner.
but the total allocation of the father of the petitioner were associated with after the date were associated with the one Hirade. Thereafter, my lord, the rational articles were there, but the unutilized amount has to be returned by the present petitioner. That's why this has been marked with the present ID.
No, I understand. I understand there is a policy. There is a policy for there is a policy. But the policy, how can you say that the policy is correct? How you giving the less quantity of articles to the ration dealers? How they can serve?
In that point, my lord, I have sought for instruction. My lord,
You get instruction.
But my lord, only
You get instruction how such way.
May I file a short affidavit, my lord?
Yes, you file affidavit. You file affidavit regarding the policy of the state.
Absolutely. In all compassionate cases, this is going on.
Yes.
Kindly take note of my lord.
No.
After 7 years.
No, whatever maybe the 7 years, 10 years, no, the issue is that why you giving the less articles to the ration dealers?
Consumer is
how they carry out the order of the consumers?
They have not returned the unutilized material.
I understand. So if the state try to reckon the unutilized amount of 10 years, it would be upon 1%.
Ultimately, the order has come. The policy.
I understand. That's why I am asking for the policy. Yes, yes. They will suffer immense. How they can serve the ration articles to the
suffering for the consumers, not the dealer.
Suffering. Yes. The only purpose that the consumer may not suffer. That is only the issue. You may impose penalty. You may impose the amount of the consumer should not be hampered.
Can you grant me short time so that the matter may be.
Okay. Having heard the learned counsel for the parties, it appears that the matter cannot be decided without exchange of affidavit. Let the state authority file the report in the form of affidavit.
Or let them file an affidavit in opposition because I have categorically stated. Let them deal with all the allegations.
Within 3 weeks from date. Reply if any by the petitioner within 2 weeks thereafter. Let the matter appear in the list on.
Or my lord,
No.
my lord,
No,
direct
no,
case to
He
consider
has done all
the
these things. How can he resolve the problem?
since my landed
No.
friend has submitted the representation is
No.
pending. Therefore, my lord,
I am hearing more matters on
Lordship,
these issues.
Lordship, tell
Let the issue be decided. Otherwise, cannot be solved like that.
Lordship.
তাহলে বিলটা হয়ে যাবে।
24th of February.
But in the meantime, they should not deduct any.
My lord,
How can it be valid? How can I serve? Kindly come to pair F. Pair F, page 70. How can I deliver to the consumers? Admittedly, they are giving me lesser quantum. Page 17, pair F. During this period.
What do you want? Rear?
F, page 17. D or F, anyone.
May I come back within 2 weeks, my lord, after exchanging affidavit?
They will give,
My lord, do not,
again deduct for the month of February.
otherwise, this is a policy, my lord. My lord,
For 1 month, after I have got the license 2021, now they are deducting.
Injuries should be suffered by the
but I'll not. That's why, my lord, I'm paying for very short time. My lord,
They
kindly
will
grant
suffer
me
again.
10 days. Let them
This
file
is,
within
this
7
is
days.
not the benefit of the ration
Dealer.
dealer or
That can be adjusted on later on if you succeed in the matter.
you can go with okay. In the meantime, there shall be an order. There shall be an order in terms of there shall be an order of stay in term of prayer F.
My lord,
Prayer F of the writ petition.
I'm get lord.
We appear on, my lord. কি বললেন just?
Same heading. 24th of February.
I'm get lord. নামটা দিয়ে দেবেন।
Next.
নামটা দিয়ে দেবেন। I'm get lord.
But 14 we appear for the petitioner.
I appear for this.
My lord,
Yeah.
Page 17, your lordship's brief. The petitioner participated in a fair price shop vacancy which was floated by the authorities at Panjipara, Goalpukhor, Uttar Dinajpur. My lord, the petitioner had participated along with some other persons as well, and a day was fixed for inspection and verification of the records. The petitioner has appended all the possible required documents which was relevant for his participation and his being successful in the bid. From starting from the certificate, no objection certificates, the certificates of the Pradhan, the banks, and so on and so forth. Everything was requisitely made. On the particular day, that is 9th of May 2024, a day was fixed for inspection and everybody was notified accordingly. The inspection team comes and visits the site of the petitioner, the proposed godown, which was constructed, and a report was purported to have been filed. No copy was served on us. The petitioner came to learn that a report which was not up to the standard and mark of the expectation of the petitioner was filed. Having regard to that information, the petitioner sought for a re-inquiry. That is at page 30 of your lordship's brief. Accordingly, the authorities responded positively and a re-inquiry was done. What has happened is, when the re-inquiry was done on the 9th of upon an inspection report being filed by them on 9th of May,
Yes.
that re-inquiry was done sometimes in the month of August, 3rd August 2024. That is after a period of 3 months, more than 3 months. And thereafter, the petitioner comes to learn that My lord, in the meantime, the specification that was found out from the re-inquiry was handed over to us, and we were satisfied, and I was satisfied, being the petitioner. The petitioner comes to learn the private respondents has been allowed with the bid, whose credentials and all other documents was again re-inspected as mine was done. Meaning thereby, my inspection was revisited after a period of 3 months, and the private respondents also was revisited after a period of 3 months. My allegation today is, my lord kindly remembers, I had indicated on the 9th of May, I was dissatisfied with the inspection. And I had made such allegations and requested them for a re-inspection, re-inquiry rather, which was accepted by them. On that very day, the private respondents were not at all in exact specifications of their required status of being a successful bidder. Their godown was not ready. Their documentations was not up to the mark. It is my allegations, and I have pleaded in the petition as well. Now, by the dint of re-inquiry of their status also, after a period of 3 months, as per my request, we had not requested for their re-inquiry. We had requested for our inquiry. Now, they have been given the leverage of making the construction which would support their claim in the final achievement of their license. Because we say that on the 9th of May, they were not ready. I had requested them, the authorities, thereafter page 33, that kindly tallies the field inspection report of that very day, 9th of May 2024, of both sides, and then passes an order. It will be clear that on 9th of May 2024, we were ready with our absolute instructions and the godown, and the private respondents were not ready. It is our specific averments in the writ petition as well as the objections raised. Now what has happened is, I have received instructions. I may be very candid to your lordship, subject to my learned senior friend saying that during the pendency of the writ petition, the private respondents have been allowed with the license, which I had apprehended in the writ petition. It was my apprehension per se in the writ petition that the private respondent is going to be appointed. By this time, it has been done. So, my lord, I am very candidly submitting, my lord, subject to correction, that probably staying of that order may not be passed by your lordships at the outset. For this interim time, my lord, I was requesting your lordships to direct the respondent authorities to file a report in the form of an affidavit with regard to the inspection status of 9th of May 2024.
What is the purpose for?
Because on the 9th of May 2024,
alleging the conduct action of the authorities.
Yes.
That your inspection may be done twice.
No.
But not the other person.
No, because I am not saying that my inspection report of 3rd of August, I am saying that on the 3rd of August, my inspection report was made by them, re-inspection or the re-inquiry. I say, my lord, the same inspection, the resultant of 9th of May was exactly the same. I had not exceeded anything on construction. The report which they have handed over to us on the 3rd of August is appended in the writ petition. Kindly directs them to file a report with regard to the 9th of May. They had also inspected. It was not with us.
It is clear from your submission that
yes,
the authority has inspected twice in respect of your
as well as both
your proposed shop-come go down.
Yes,
as well as the other parties.
Yes, but
so what they have done?
What they have done, the problem they have created is On the 9th of May, my inspection was wrong.
There is a vacant land.
No, no,
What
no.
is the
My
issue?
inspection was not made correctly by them because there were
Whatever
construction.
they have inspected correctly your location
No, no.
later on.
No. On the 9th of May, they have inspected.
Whatever may be the 9th of May,
My
they have inspected twice your location.
Yes.
They have inspected twice the location of
Yes.
the private respondent.
Yes.
So end result is
Yes.
the last inspection report.
No, my lord, subject to correction, my lord.
What is the
My lord,
what you
my
want?
lord, my lord,
Your last inspection is correct.
No, no,
The
no.
last inspection report other or is incorrect.
No, my first inspection was also correct.
So
Which they have suppressed, which they have not supplied.
So why you prefer?
Because it was based on the basis of my first inspection report also,
No.
the authorities has not taken any steps. Hence, I had complained of. On the basis of the first inspection report also, I was not handed over.
The ground you have raised here,
Oh,
that is the action of the
Authorities on the 9th of May.
Whether it is arbitrary or not, this is
Yes.
the issue.
Even today on instruction I submit, my lord, even today the respondent numbers, private respondents are not ready with their go down, but still they have been issued. I am not, my lord, making my argument thus far with regard to today's essence. On the 9th of May, my lord, there are 2 inspection report on the 9th of May with their with the authorities. I was requesting your lordship without, my lord, adventuring into any further in this matter, my lord, let those reports be filed before your lordships. I will be out of court if my credentials are bad with regard to
He is
private
already out of court. His cause of action does not survive. The private respondent is not here. After being unsuccessful, he is here. He is saying many things or by even afterthought. My lordship, he says the second inspection report, after the first inspection report, after the second inspection report, the first inspection report also does not survive. It goes.
Yes.
And he is unsuccessful. And the private respondent, I don't know whether the private respondent has been served or not. The license has been issued in his favor and he is running. On his own admission, he is has been issued.
Lord, I am not, my lord, I have handicap with the affidavit of service today, my lord. But I am not seeking any order against the private respondents.
No, no.
As of now, as of today.
He has been successful in this matter, so
Yes.
you have to serve.
My lord, I have served probably. My lord, I have
license has
served.
been issued. License has been issued in his favor.
Yes. I have said that at the outset. I have said that license has been issued.
Serve and come.
But
Next week.
let it be taken up on Monday, my lord. Then
Next week.
yes.
Monday.
Next Monday. Lordship is
In
not
that-
passing any order today.
No, my lord. In that event, my lord. In that event, my lord, I was just humbly beseeching once again, my lord, at the cost of repetition. Let them, my lord, file those 2 inspection report, my lord, on the 9th of May. That is the whole pith and
You
substance.
serve private respondent and
Whole pith and substance of the story.
affidavit. Thereafter, I will pass
Grateful.
the order.
Lordship kindly records that he has not filed an affidavit of service.
My lord,
showing
it is-
service among the private respondent. Let that be recorded at
No, not necessary. Come on Monday. I am not passing any order.
Very well.
Grateful.
Next.
Lordship, I'm acting on behalf of the private respondent, number 7, Your Lordship. 17.
Where is the petitioner?
Lordship, I make it not to the Lordship. 17.
Why? Second call, not today means not this week. Not this week. Call next matter.
Second one. Second.
Not this week.
Lordship, I am for the petitioner, Lordship. This is a supplementary affidavit, Lordship.
What supplementary affidavit?
Lordship,
Are you allowed to file supplementary affidavit?
so Lordship, I am appearing for the state led by Ms. Sonal Singh. Lordship, operative paragraph is para 3, Lordship.
Are you allowed to file supplementary affidavit? Then when you come with the supplementary affidavit.
Lordship, then kindly make it not today, Lordship. I have to
Not this
take
week.
instruction.
Next.
My Lord, I beg to appear for the respondent number 7, the private respondent.
I'm for the state led by Mr. Sen.
Where is the petitioner? Which for the petitioner? Give me file.
Lordship,
Mr.
You are for the petitioner.
Timir Boron Shah is appearing on behalf of the petitioner.
In this matter? No, no, no. Mr. Saha is not there. This is item number 20.
20, Mr. Shah is appearing. Timir Boron
Shah is
Shah.
appearing?
Yes, my lord. His clerk.
Okay,
intimates
okay,
him.
okay.
Kindly make it not today, your lordship.
Very well, not today.
Great.
Come on tomorrow. Next.
আরে কত আছে বলো তো আমার ফোন বন্ধ। কালকে ওয়েডনেসডে, কালকে কি আছে সেখানে ফার্স্ট হাফে এগুলোই থাকছে। বুঝলি তো? তাহলে ফার্স্ট হাফে অ্যাপ্লিকেশন দেবেন, তারপরে কন্টেন্ট দেবেন, কি আছে পাঠাড নিউ মোশন একটা আছে 10:30। তাহলে নিউ মোশন স্পেশাল ফিক্স ওটা দেবেন, আর তারপরে দেবেন হচ্ছে অ্যাপ্লিকেশন, তারপরে কন্টেন্ট, তারপরে মোশন দেবেন। ঠিক আছে, লিস্ট করবেন, প্রথমে দেবেন হচ্ছে ওইটা, তারপরে অ্যাপ্লিকেশন, তারপরে কন্টেন্ট, তারপরে দেবেন হচ্ছে নিউ মোশন। ঠিক আছে, তারপরে যেরকম লিস্ট আছে লিস্ট রান করবেন। Let me call 43. Okay, হয়ে গেছে, ছেড়ে দিন।
Well, my lord has part-time owner appearing in the letter, my lord, for the state.
Item number 12. কাশীনাথ দত্ত কি করেছে ডাইরেকশন? You file affidavit in opposition, give your name. No. Not very.
It's not given opposition side.
Give your name.
ওখানে ডিরেকশন ঠিক আছে, ঠিক আছে।